And so right up top, there's a few things to note and be aware of. I always highlight for people, even though I don't think that people necessarily are aware of this, which is this very first line up here, date prepared. I think a lot of people's eyes skim right over that, but that's actually an important line that you need to fill out. And so the reason for that is when you do an addendum to the contract or an amendment later or an additional form, it'll always reference, this is an addendum to the RPA dated. This is the date you use, because there's a lot of other floating dates in the contract. There's the date the buyers sign it. There's the date, hopefully, that the sellers accept it or they counter it. So because you have so many different floating time frames, you always want to have one fixed date that you can always refer back to. This is the contract dated August 19th. And so for that reason, that's why you see that date prepared line. You're going to put the date in when you start filling it out, and that will be your reference point whenever you refer back to the contract as we go forward. So paragraph 1, this should look pretty familiar. This is where you put the basic information about the buyer making the offer and the property that the offer is being made on. You'll identify the buyer, could be an individual, could be a couple of individuals, could be an entity. We'll talk later about what you need to know if the buyer is maybe an LLC or some other type of entity. Then you have the information to identify the property. One quick thing to note here, it used to say the real property to be acquired is, now it just says the property. And we'll talk about why that change was made, but it has to do with the potential for using this form on a manufactured or mobile home, as opposed to necessarily a piece of just real property. But generally, you're writing it for the property to be acquired, street address, the city, the county, and then there's a place to put in assessor's parcel number, the APN, or assessor parcel numbers. In the event that you might have an offer on more than one parcel at a time, sometimes I'll speak to buyer's agents who say, well, the buyer wants to purchase this lot and the lot next door, or 2 lots owned by the same buyer. In that case, you just make sure you identify all of the information, all of the parcel numbers in that line. And there is a note that a postal or mailing address may be different from city jurisdiction. So buyers should always confirm that the address that they see for the property is in fact the correct city jurisdiction for where the property is located, in case that affects municipal codes, local rules, zoning regulations, things like that. And then, of course, right here in paragraph C, this is a big significant change from the previous version of this contract, where it used to say, the purchase price will be, the closing date will be. Well, now all of that information is contained down in the grid in paragraph 3. So it's notifying the parties right away that the terms of the purchase are specified below and in the following pages. So we've identified the property, we've identified the buyer, and now we're going to go down to actually see what the terms of the offer and the contract are going to be. And in 1D, we have our first of what will be multiple references in this contract, reminding everybody that the buyer and seller are the parties to the contract, and that brokers and agents are not parties to the agreement. So even though broker and agent information will be mentioned many times throughout the RPA, brokers and agents themselves are not parties to the contract. All right, agency. This is all pretty much the same as it has been in previous versions of the contract, if only because agency disclosure and confirmation is really covered by California law, and not something that we really can or would make a lot of modifications to. So the first thing to note here, there's a reference to the parties acknowledging that they've received a disclosure regarding real estate agency relationships, or Form AD. So when you go and pull up this form in your online forms library service, whichever one you use, you will see, before you see page 1 of the contract, the first thing you'll actually see is page 1 of the agency disclosure form, the AD form. And the reason for that is that because by law, before a buyer signs a purchase agreement, they have to sign the agency disclosure. You have to provide them with the agency disclosure. You have to double check that, or not double check, excuse me. You have to confirm that they understand agency and get them to sign that. That's required by California law. And the same thing is true of the listing side as well. Just so you know, when you're taking a listing, the agency disclosure is what comes up first in front of the listing agreement, because by law, a listing agent has to give their seller that agency disclosure in advance. So the listing agent gives their client, the seller, an agency disclosure at the time of the listing. And then the buyer's agent gives their client, buyer, an agency disclosure at the time the offer is written up. And there is a note here, because this has been a common question over the years. You'll see it actually instructs the parties, buyer's agent is not legally required to give the seller's agent the AD form signed by buyer, and seller's agent is not legally obligated to give buyer's agents the AD form signed by seller. Essentially, that means there's no obligation to exchange agency disclosures. You're responsible to give the agency disclosure to your own client and keep that for your file, but there is no obligation. Sometimes people will ask, because the way it comes attached, sometimes it just automatically attaches. There's nothing wrong with exchanging it, but there's no legal obligation for the agents to swap agency disclosures. As long as you've given one to your own client, you are in good shape. The second section, 2B, this is also unchanged from the prior version of the contract, is agency confirmation. Similarly, this is also required by California law, comes straight from the Civil Code, where when you are representing a client in a transaction, you need to confirm that agency relationship into the contract, in the contract itself. So there's a place to note the brokerage firm representing the seller, and if they're representing the seller exclusively or they're a dual agent, same thing for the agent, and then buyer's brokerage firm, buyer only, or both the buyer and the seller as a dual agent. So the one thing I always want to highlight in this section that's important to remember is that because agency flows through the broker, if the broker is a dual agent, all of the agents involved in the transaction is a dual agent. So I know that often, especially in a larger brokerage, you may have a situation where one agent in an office has the listing and a other agent in the office who may or not even know the other agent, may or may not even know their clients, brings the buyer, writes up the offer, and the transaction more or less operates as if the one agent represents the seller exclusively and the other represents the buyer exclusively. And that's a good way to conduct a transaction, to have designated roles where someone is focusing on working with the seller, someone is focusing on working with the buyer. But from a legal standpoint, if those agents share a broker, then the broker is a dual agent and both agents are as well. So what that means is when you're filling out this agency confirmation section, if the box is checked for seller's brokerage firm representing both buyer and seller as a dual agent, then that box should be checked the same for every broker and agent in the remainder of that section. And my understanding is that in most forms programs, that's how it will work automatically. You check that box, it should autofill the rest saying, okay, everybody involved is a dual agent. And you'll have the name of the brokerage, the license number, and then the name of the agents and their license number. One new thing that was added here in 2C is the option to acknowledge if there is more than one brokerage representing the buyer or seller. So if it's a co-listing arrangement, or if for some reason there's two brokerages working with the buyer, then you can acknowledge that right here. You'll obviously only have room to acknowledge one broker for each side in this section, but you can check the box in 2C and acknowledge that more than one brokerage represents either seller or buyer, and then attach a form called the additional broker acknowledgement, which basically will act to bring up that form, and then you can put all of this information for the additional brokerage onto that additional form and have everything covered in the contract. Last agency note here, potentially competing buyers and sellers. there is a second agency disclosure form that comes along with the purchase contract automatically attached. So after the AD form, the agency disclosure, then you will see that there is a second form, the PRBS, possible representation of more than one buyer or seller, disclosure and consent, that also comes attached to the contract. And that form basically, I always think of it as it explains to clients some of the realities about how the real estate industry works. You could have more than one agent in an office representing competing buyers. Even the same agent, in some circumstances, could have two buyers interested in the same property, or you could have two sellers who are in the same neighborhood or market area competing for the same buyers. Basically letting them know there is this possibility for these multiple interests being represented. Also, true dual agency being an option. And by signing that PRBS form, the buyers and sellers consent to those types of relationships. So now we move on to paragraph 3. This is the big one. And this is, I think, the biggest sort of shock to people when they look at this new RPA for the first time, biggest formatting change, but I really think it's a fantastic change that's been made here. I really like the way this has been set up, and I think everyone's going to really enjoy it as well. Basically, as it says right here in paragraph 3, the items in this paragraph are contractual terms of the agreement, and then referenced paragraphs provide further explanation. It reminds the parties the form is 16 pages, so the parties are advised to read all 16 pages. And that's the biggest thing to hit home from my perspective, and when you're talking to your clients as well, which is the grid is great. It really makes sure that you don't miss anything important, but it is not the only part of the contract you need to read. There is a ton of important information in the body of the contract beyond just the grid. It's just that these are the only modifiable terms, the only terms that you can change, move dates, negotiating points, but the rest of the contract remains extremely important as well. So, like I said, this is a way to focus your attention, but it's not just a summary. It's not the only thing you need to know, but it definitely has the really vital info that you don't want your clients to miss out on. So starting with here, paragraph 3A through F, we are talking about basically the financial terms of the purchase. So we have the purchase price in 3A right there, where you're going to put the dollar amount that the buyer is offering. And then you'll see in these additional terms, this is where you can make modifications or provide some context to the terms that are being put into the contract. So you'll have your purchase price. And if it's an all cash offer, then the box right here up top, check the box for all cash. So one of the easiest things for a seller to see, if it's an all cash offer. If it is all cash, then these sections down here about loan and further down about loan contingency, those aren't going to apply because it's not going to be contingent on the buyer getting a loan. The buyer basically is saying, I don't need a loan. I have the money right now. Then you have the date for close of escrow. And one good change that was made here is it now defaults to a certain number of days after acceptance. So it used to be in the old version, it said the close of escrow will be such and such date, like a fixed date, or you could change it to so many days after acceptance. But in most cases, the vast majority of time, the preferable way to set it up is to have it be a certain number of days after acceptance, because you never know how long the negotiating period is going to take. So if you write up an offer today and say, let's close in 30 days on September 19th, but then you spend a week or more in counter offers, now you've lost all that time and you still have a fixed closing date. So most of the time you're going to see writing up an offer 30 days, 45 days, 60 days, whatever that time period is that the buyer thinks they're going to need to close the escrow. Really, the only time that you're going to use a fixed date here is if the buyer has or the seller has a hard deadline, whether for tax reasons or for moving reasons, job reasons, whatever the case may be, if they say, I have to close no later than September 30th, then you can put September 30th in there and stick with that date, or more traditionally, certain number of days. Another big change is that expiration of offer has been moved up top. The expiration of offer used to be all the way down at the bottom by the signatures. And so if a buyer had changed this time period, maybe they wanted a response in 1 day, then that would have been buried at the back. So right now, it's front and center, expiration of offer. The default is still 3 calendar days after buyer's signature at 5 p.m., or you could put in a particular date instead to alternate or change that time period. And the reason there's no paragraph number for close of escrow is because there's no additional reference in the contract that talks about close of escrow. This just is the date, is the information. There's a definition of close of escrow further on at the very end of the purchase agreement, but really there's no additional paragraph that expounds on it. Deposits. So this is very similar to before, but there is an interesting addition here, which is a place to put in the the initial deposit amount. Then there's a place to note it as a percentage of the purchase price. Now, the contract itself clarifies that the percentage number above is for calculation purposes only and is not a contractual term. So what does that mean? It means that if you put in a deposit amount in this line, and let's say it's 3% of the purchase price, which is typically the maximum for liquidated damages reasons, if there's counter offers in the contract and the purchase agreement and the purchase price is increased, the deposit amount does not automatically increase percentage-wise. So that would need to be countered specifically. The percentage number that's there is just for context and for information, but the initial deposit amount is governed by the dollar amount and does not automatically adjust if the purchase price adjusts. And then in the box next to it, that's where we have our time frame. So we have the dollar amount for the deposit, and then what is the timeline for getting the deposit into escrow? The default is 3 business days after acceptance, and the default is by wire transfer. Then there's an option for or and a checkbox if the buyer wants to put in the deposit via different means. If they want to do a cashier's check of some kind, or some other system for getting the deposit into escrow, they can put that in there. The deposit by default is by wire transfer. And there will be a note later on in the escrow section when we get there that does clarify and say, buyer, you can elect whatever sort of means you want for getting the deposit into escrow, but ultimately it is going to be escrow's choice. If escrow says, no, you have to do wire transfer, then essentially the buyer has to do wire transfer. It's really going to be escrow's call in the end, but the buyer can choose a different method and see if escrow will accept it in this section. Then after the initial deposit amount, there is an option, a checkbox for if the buyer wants to offer an increased deposit, which would be money placed into escrow after the initial deposit. And then there's a reference to an additional form that would be used, Form DID, that stands for Delivery of Increased Deposit. It used to be RID, which is called Receipt for Increased Deposit, but it's been changed, DID, Delivery of Increased Deposit, that if the buyer is putting money into escrow in 2 stages, there's a place to put that second dollar amount, and then acknowledging what the time frame would be. The default is the most common arrangement, which is upon removal of contingencies. So maybe the buyer puts in, a certain dollar amount or a certain percentage, 2% of the purchase price as a deposit, and then upon removal of contingencies, they bring in an additional amount to really lock in the deal, show how serious they are. But you could also set a particular date or another milestone of the contract when a buyer might choose to bring in an initial deposit. moving on to the next section, talking about the loan amounts. Couple of changes here to be aware of, but most important thing to know, this is where you put in the amount of the loan that the buyer is getting. And this section is really important because when we talk about the loan contingency in a little bit, it will say that the contract is contingent on the buyer obtaining the loan identified in this section. So the buyer should be putting in here, this is the loan that they expect to get, that they're pre-qualified for, that they're comfortable purchasing the property as long as they can get this loan. This will be the basis for their loan contingency. This also has the addition of the loan as percentage of purchase price. The default is that they're getting a fixed rate loan. If they're getting an adjustable rate loan, they can put a limit on the initial adjustable rate. And then a new default here is that it used to just say buyer to pay blank points. Well, now the default is buyer to pay 0 points or up to a certain percentage for points calculation if the buyer, for whatever reason, needs to be getting a loan that has points with it. Also, the default is that it's a conventional loan. If the buyer is not getting a conventional loan, if they are pursuing FHA or VA financing, that needs to be checked in this section because it implicates the transaction in some pretty significant ways, one of which being the addition of the FVAC form, the FHA and VA Mandatory Clause, which affects the buyer's rights when it comes to appraisal issues. And we'll talk about that when we get down to paragraph 5, where it expands on some of these terms. But the big change here to be aware of, new default time period for the loan contingency. It's down to 17 days. So no more 17 days for everything but loan that's 21. Now every contingency defaults to 17 days. It can, of course, be changed 17 or blank days after acceptance if the buyer needs to ask for more time to get their loan approval and be comfortable removing the loan contingency. That can absolutely be modified here, but the default is for 17 days. In terms of why was that decision made? Unfortunately, I do not know. I would be completely guessing to say simply to bring all the default contingency timeframes in line, but it is important to be aware of because 17 days is a really short time period. And so many buyers may want to modify that default and lengthen that contingency to give them more time to get their loan approved. And then if I saw someone had a question about what if you're getting a different type of loan, there is an other here. So if you're getting FHA or VA, there's checkboxes. If you're asking for seller carryback financing, there's a checkbox. And then other, if you're getting another type of loan, USDA loan, other sort of subsidized loan program, that can be noted down here where there's a checkbox and write that into the other section. And then the acronym was the FVAC for the FHA VA Mandatory Clause. The 17-day reference here, it is for the requirement if the buyer is getting an FHA or VA loan and the lender requires repairs, the buyer has a 17-day time frame to submit that request to the seller to have those repairs taken care of. Still negotiable, even if their lender required repairs, the seller can still say no. But it's important for a buyer to convey to a seller if repairs are lender required, because obviously if the seller does exercise their right to say no to those repairs, that's going to be basically the end of that transaction. And then, second part here, doesn't come up super often, but in the event that the buyer is having an additional financed amount, they are getting a second loan or financing an additional portion, then that would be noted here. Again, defaults to conventional. Sometimes seller will carry back a portion as a second. That could be noted here as well if the buyer is getting a second additional financed amount for the loan. And then another new change, this has always been in the contract. It used to be further down, but asks about the occupancy type. So the occupancy type, basically the buyer is disclosing up front if they are purchasing this property to be their primary residence, or if it's going to be a second home or an investment property. And really that reason is there for financing purposes. The availability of financing to the buyer will depend on how the property is going to be used. And so pretty much all lenders require the contract to state what type of property this is going to be, how it's going to be used by the buyer. It used to be just this will or will not be primary residence, but now in this new version of the contract, a little bit more flexibility to say primary or secondary or investment property. Here's a new section here in paragraph 3G1. There is now a default section to ask for a seller credit, if there will be any, to the buyer. So instead of just having that written in other terms or financing terms or things like that, now there is a default section. If the buyer wants to ask for a credit, they can do so right here for whatever dollar amount they want. And the default is that the seller credit will be applied to closing costs. And then there's always an option. If they want to be applied to something different, they can request for that. But the default is the buyer can ask for a certain dollar amount from seller credited at closing and have it be applied to closing costs. So built that right in there. It was such a common term that was being written in that now there's a dedicated line for it. Can go straight in. You don't have to make up your own language, which is always a good thing. Beyond that, if there are any additional financing terms, anything else that needs to be noted about the way the buyer is financing the property, you can always put that in there. And then section 3H here talks about the verification of buyer's funds. So all of these defaults now are that all verifications are attached to the offer. So if the buyer's paying all cash, then verification of sufficient funds to pay all cash for the property is supposed to be attached to the offer, excuse me. If the buyer, for whatever reason, wants to provide that later, you can always, in all these sections, check the box and say 3 or blank days after acceptance. But default will be attached to the offer to show buyer's qualifications. Same thing with verification of down payment and closing costs and verification of loan application. So the buyer is going to be expected to attach their loan application qualification documents and their verification of down payment and closing costs, which could be standalone, it could be a part of their loan qualification letter, to the offer up front. Seems to be what sellers always want to see anyway. So that is now the additional change there. Yeah, for if lenders want to see recurring and non-recurring, you could always add that language here in that other line as well. And that is a good note because, yeah, if lenders want to see that, you can add that into the additional section. And then final note on financing issues. Loan application, there is now a spot to identify what type of loan application qualification is the buyer providing. Is it a pre-qual? Is it a pre-approval or a fully underwritten pre-approval? So obviously that's sort of, 3 standards of strength of the pre-qualification. How thorough has the review been? How much has the lender vetted the buyer? And this way the buyer can say, well, I just have a pre-qual letter, or I've been pre-approved, or I have a fully underwritten pre-approval. Basically, so the seller really understands what kind of peace of mind they're getting about the buyer's qualification. All right. And just a quick note here about what would be paragraph I. You'll notice here and in one other place, here in paragraph I, intentionally left blank. The entire reason for that is an I looks like a 1, and it can be very confusing if you have both a paragraph I and a paragraph 1. If you're trying to reference paragraphs later, it creates unnecessary confusion. So that's all. There's nothing more to it than that. Just I is left blank to avoid any confusion in writing out paragraph numbers. Now we're getting into some more actually outside of financial contract timeframes. Final walkthrough timeframe, final verification of condition. This is the same default time as before. buyer has a right to do a final walkthrough, do a final verification of condition within 5 days prior to close of escrow. If that time frame needs to be altered for any reason, it can be right here, but 5 days is the default. And then this is another new provision, and we'll talk about it further on down in paragraph 23, but assignment request. So paragraph 23 talks about the buyer's right to assign the property in certain cases with sellers, whether or not they need seller's approval, depending on the circumstances. But if the buyer would like to assign all or a portion of their interest in the contract and they need seller's approval to do so, now there is a time frame for that. There is 17 days for them to submit that request and for the seller to approve it. And when we get to paragraph 23, we'll talk about how that procedure works. But just keep in mind, there is a time frame on that. I've spoken to many agents over the years frustrated by a last minute assignment request, day 25, day 30. Now the buyer wants to swap a buyer, add somebody on. And it can be a bit of a paperwork headache or an inconvenience at that point. So if the buyer even thinks there's a chance they're going to need to assign the contract, all or a portion of it, needs to happen within the 17 days. Can the seller deny that request? In certain circumstances, and almost always if it comes after the 17 days. So we'll talk about it in paragraph 23. If they make the request within 17 days, the seller's consent cannot be unreasonably withheld. So basically, as long as the request is made within that 17 days, the expectation is, as long as it's not going to cost the seller significant time or money or anything like that, the expectation is they consent. But they could say no if it's going to cause a major problem with the transaction. And then if that request comes late after the 17 days, then the seller could reasonably say no, it's too late. We're not going to do this at this point. So hopefully that does avoid a lot of those last minute day of closing, we're going to add a buyer at the last second headaches that I know some people have been through.
Paragraph 3L, contingencies. So this section I think is particularly great because it lays out all of the contingencies in the contract in one place with all the time frames. So no more sort of looking at a couple contingencies in paragraph 3, then going to paragraph 14 to look at the rest of the contingencies. Everything is here. So this is a good place to see what all the contingencies in the contract are and what all those time frames are. As I unintentionally previewed for you earlier, it's 17 days across the board now. Loan 17, appraisal 17, pretty much the default is 17 days for your contingency period. Now, couple things to note here. Loan contingency still has the checkbox to say no loan contingency. So you don't need to sign a separate contingency removal form if the loan contingency is being waived up front. If the buyer is waiving the loan contingency, they can check the box right here. Appraisal contingency now, there have a couple of really important changes to be aware of. The first here is the language about the appraisal contingency. It says appraisal contingency based upon appraised value at a minimum of purchase price or dollar amount. So any of you who've been doing deals over this past year and a half, I'm sure have encountered some creatively written appraisal clauses. You see people writing in the language that the buyer will make up the difference if the appraisal comes in at a certain value or a certain amount less than what the purchase price is. This is a way to do that that's built directly into the contract. So let's say you're writing up a purchase contract that's for $500,000. By default, the contract is contingent on an appraisal coming in at $500,000. But let's say your buyer wants to write a little bit more of an aggressive offer and they're willing to make up some difference. Maybe the buyer's willing to make up $10,000 if the appraisal comes in within that window. So in that case, you would check the box here and write in the other amount. And this, in my example, $490,000. So the appraisal, and basically saying that as long as the appraisal comes in at that dollar amount, buyer is willing to make up whatever the difference is to get the deal closed. So totally optional. The default still is and will remain that it's contingent on appraisal coming in at purchase price. Most buyers needed the appraisal to come in at the purchase price in order to get their loan and close. They very well may not be able to bring in any extra cash, but if they are and they want to signal that to the seller, they can use this line and say, okay, actually it's contingent on an appraisal coming in at some amount less than the purchase price, and I, buyer, will make up the difference. Then, of course, the alternative is the even more aggressive approach is, just like you can in the contract now, check the box for no appraisal contingency. So the buyer can also just waive the appraisal contingency altogether, which basically means no matter what the appraised value comes in at, then the buyer's obligating themselves to bring in the money to make up the difference and close the deal, no matter what the appraisal comes in, if they waive that appraisal contingency up front. However, big note here, and this has always been the case, but this is one of those situations where I think it's good to have this information put into the purchase agreement itself, because there was some confusion about this element, which is removal of the appraisal contingency does not eliminate appraisal cancellation rights in the FVAC. So this is a reference again to that FHA VA Mandatory Clause. Yeah, exactly. This clears up that question, which is, so that if you haven't seen the FHA VA Mandatory Clause, what it says is it says that notwithstanding any other provision in the contract, if the property fails to appraise at purchase price, the buyer can walk away. So it's basically a supercharged appraisal contingency. An FHA or VA borrower can't waive the appraisal contingency. They're protected by this legally required form. So this is just to let a seller know so they don't get, sort of confused into thinking, oh, great, my buyer waived the appraisal contingency, they're locked in. If it's an FHA or VA borrower, it is just not possible to have them waive that contingency. They retain that right. You can still ask them to remove, you can still ask them to remove the contingency, but in the event that the appraisal comes in low, they will retain the right to cancel the contract. All right. So investigation of property. So now we're going to talk about the rest of the contingencies here. Buyer investigation, 17 days. And we'll talk a little bit about what the investigation entails when we get further down. But that's your inspections. That's your confirming insurability. Basically, buyers satisfying themselves with the condition of the property and matters affecting the property. Now, the second section here, informational access to property. This is actually already in the purchase agreement. There is already a section in the current RPA in paragraph 14 that specifically states that even if the buyer waives the inspection contingency, they still have the right to access the property. They still can come on and do inspections. They still, they just can't cancel the contract based on what they find out. Maybe they want to, do measurements and get a sense of if they want to do remodeling work after closing and things like that. There's all kinds of reasons why a buyer may want to come on and do inspections on the property, even if those inspections don't end up giving them any cancellation rights, but they still have the right to access the property. Although there is a warning in here for the buyer, is that it's for informational purposes only, and it's not a contingency. By waiving the investigation contingency, anything they find out, they can't cancel now. So, it's, as always, incredibly risky for a buyer to waive this contingency up front. It's definitely more common than it used to be. I know in some parts of the state, maybe where many of you are from, it's been, sort of regular for a while. But definitely in the more competitive market of the past year, there's been more upfront waiving of investigation contingencies. But, there's risks involved. And so the buyer's being warned that, look, you waived this contingency. You can still do your inspections, but you're not going to be able to walk away if the inspection reveals information to the buyer that they did not know previously, unfortunately. So as far as buyer due diligence goes, there's a few more contingencies tied to buyer's due diligence process. Review of seller documents, basically the disclosure contingency. The buyer has by default 17 days after acceptance to review the disclosures and reports and other information provided by the seller. Now, a really good change here is the way that this actually describes the potential extension of buyer's contingency rights if there is a late delivery of documents. So now it says for seller documents, for the title report, for the HOA documents, and then also for reviewing leased or liened items if there are PACE or hero liens or things like that on the property. Buyer has 17 days after acceptance or 5 days after receipt, whichever is later. And this has always been the case. The language was, again, just buried in the back of the contract that said if disclosures are delivered late, then the buyer might have this extended time period. So now it's just described up front so that everybody's aware, 17 days for these reviews, but if the buyer doesn't get these documents until day 15 or even later, then that's going to extend out their contingency cancellation time period. If the buyer wants to remove any of these contingencies up front, the way to do it is by attaching a contingency removal form and identifying which contingencies are going to be removed. There is a sort of advisory here that removal or waiver at time of offer is against agent advice. Buyers taking a risk. If they waive the contingencies up front, they are, putting their deposit at risk if they find out something they don't like or if something potentially goes wrong. But many buyers still choose to do that. They can do so at their own risk. And then paragraph L8 here is the last contingency referenced in the contract, which is contingency for sale of buyer's property. Basically, if the buyer needs to sell their current property, if they currently own a home and they need to sell it in order to make this purchase, then there's a box to check to make this contract contingent on the sale of their current property. That will attach the COP form. That form is another almost 2-page long form that lays out the provisions of the contingency for sale of buyer's property. So there's nothing else about that provision in the purchase contract. If the buyer needs a contingency for the sale of their property, that box will be checked, and then those terms will be negotiated on the COP. The reason why the language says box above is because it says any contingency may be removed or waived by checking the applicable box above, which is the loan or appraisal contingency boxes, or attaching the CR form and checking the box therein. So to remove loan and appraisal, you check right there on the contract. If they want to remove additional ones, then you can check this box, attach the standalone contingency removal form, and remove the contingencies there.
Let's talk time of possession. There's a pretty interesting change in this section as well. So, time for possession. This is when does the property need to be turned over? When does the property need to be empty and keys handed to the buyer? Under the new form that we're looking at right here, time of possession is going to be upon notice of recordation. So basically, as soon as parties get the word that the deed is recorded, it's now in the buyer's name, it's now the buyer's property, and that is the time for possession to be delivered and keys to be exchanged. You can modify that to a set time period. So you can say or 6 p.m. or noon or whatever time if the parties would rather have a set time period. So they're not just, they're already going to be on pins and needles waiting for confirmation of the recording. But for scheduling purposes, they can set a particular time period for possession to be turned over to the buyer. And the default is that it happens on the date that title is transferred and the deed is recorded. So, yeah, I think this will be a good change. A lot of buyers, understandably, are extremely antsy to get their keys and get possession of the property as soon as it's recorded and in their name. So that is going to be the current default. But of course, there are often sellers who, for various reasons, need to ask for additional time after closing before they turn over possession of the property. And so there are two options here for when the date will be. So if there's going to be a delay, then so the default is still close of escrow date. But they can check below for different options. And this is typically for a seller occupied property. So if the seller wants to do a rent back or a lease back, then they can check a box and say for 29 days or fewer, then, so basically checkbox 1, you could put 1 through 29 in that blank. Or if it's going to be 30 or more days, use the second blank. And the reason why there's 2 lines there is because depending on which box you checked is going to affect which form the buyers use and the sellers use for their rent back. So up to 29 days, there's the seller license to remain in possession form. That's sort of a short seller occupancy agreement when they're going to stay for less than a month, up to 29 days. If the seller is going to retain possession for 30 or more days, then it really becomes a true lease back. And then you're going to be using the RLAS, the residential lease after sale, which is basically a full rent back lease agreement between buyers and sellers who are now sort of owners and tenants. And then finally, if it's a tenant occupied property, there is a new procedure in place. So if there's a tenant occupied property, whether it's a single family residence with tenants in it, or if it's a multi-unit property and 1 or more of, up to 4, so 1 to 4 of the units is occupied by tenants, then that box would be checked. And there's going to be a new form that's going to be attached, the Tenant Occupied Property Addendum. This is replacing the TIP, which was the Tenant in Possession Addendum. Now we have the Tenant Occupied Property Addendum, which will be provided anytime the property being sold is occupied by tenants, whether or not those tenants are going to be vacating at closing. So on that additional form, which again will be available in December when a new RPA comes out, that will be a standalone form where the seller will disclose what's happening with the tenants and will basically say whether or not when the tenants are going to be moving out. If it's prior closing, if it's some date in the future, that'll be disclosed and negotiated on that form if the property being sold is tenant occupied. Next set of timeframes has to do with delivering documents and paying fees and establishing legal compliance with some conditions on the property. So this is the same time period as it's been in the contract previously. Seller has 7 days after acceptance to deliver any documents they're responsible for. That is typically going to be your disclosures. It could also be inspection reports that the seller is obligated to provide by the contract, by law. All of that default time period, seller has 7 days to deliver those documents. And we've also already mentioned what happens if those are delivered late. Depending on how late they're delivered, it can push back the buyer's contingency period. So really important to get those seller documents in that first 7-day time period. A couple other time periods here. 5 days for the parties to sign and return the escrow holders' escrow instructions, basically. This also has been in the contract previously in the escrow section, but really wanting to bring this front and center. You don't want either side delaying signing escrow instructions to cause any complications in the transaction. So there's a 5-day window for both buyer and seller to sign and return those escrow instructions. If there are HOA documents in the property, seller has 3 days after acceptance to order the HOA documents. I always advise people, don't wait to the last second. HOA documents can take some time to provide. It's always frustrating when you're sort of dealing with a third party who's responsible for bringing in documents that can affect the timeframes of your transaction. So this earlier the better. At the earliest opportunity, sellers should be ordering those HOA documents to make sure they come in as soon as possible. And then here's a new time frame. This was not in the previous contract, but this is something that did sometimes cause last minute issues. And so now we have a time frame for it, which is the time frame for installing smoke alarms, carbon monoxide detectors, and having the water heater braced and strapped for earthquake safety. So these are basically the 3 legal requirements in California. There's very little that the seller has to do when they sell real property. They can almost always sell the property as is, but when they are selling in California, certain health and safety codes need to be complied with, and that has to do with installing smoke alarms, carbon monoxide detectors, and having the water heater braced. And so the seller has 7 days after acceptance to make sure that it's taken care of. And so that way it's done up front, like someone just noted in the chat. This really is because the failure to do these things ahead of time can impact buyer's appraisal often, and then the appraiser has to come back out. And so this way, done early on, and that way it doesn't cause any problems further down in the transaction. All right, paragraph O here. This is our second intentionally left blank. No looks like a 0. And so to avoid confusion, so that people don't think that O is 0 and get confused, paragraph O, intentionally left blank. This is one of my favorite new paragraphs in the entire contract. Paragraph 3P1 here lists out items included and excluded from sale. Always a major headache, major hotline call when the parties, the buyers and sellers, have some communication issue, miscommunication, misunderstanding about what contracts are included, or excuse me, what items are included in the contract for the sale of the property and what items aren't. So a lot of these have been in here previously. Your appliances are pretty standard. People know that they should check boxes to have appliances included or not. But what we've discovered over the past few years is there are additional items that tend to cause a lot of disputes and headaches. For example, if you say all refrigerators are included, does that include wine refrigerators? Well, now there's a separate checkbox to confirm whether or not a standalone wine chiller, wine refrigerator is included. Video doorbells, that's been a big one. Various sort of fancy security video doorbells, are those included? They have a checkbox now to say yes or no. Security systems, brackets for audio or video equipment, if you want those to stay with the property, there's a checkbox. Above ground pools or spas, there was always some confusion where, you know, people see a spa, they get excited, and then the seller takes it away, buyers are disappointed. There's now a place to specify whether any above ground pools or spas are going to stay on the property. Electric car charging systems and potted trees and shrubs. These are just things that if they're not checked, the seller is taking them away from the property unless they're fixtures. You know, there's certain appliances are built in and those stay. We'll talk about that in paragraph 9. But for personal property items that the seller might take away with them, this is the place for the buyer to make sure that they ask to have those items included. All right, and yeah, the where it says things like stoves, refrigerators, those, you know, the S's are, they're all included unless there's some reason if they don't want a garage, fridge or freezer, you could exclude that separately. But if you're checking those boxes, all of those items are included in the sale. There is a section that speaks to solar leases, and we will get to that pretty shortly here. And just so, good question about water fountains. This list is incomplete. This is not everything that is included. We'll get down to paragraph 9. These are just ones that are most commonly requested and are negotiable, but certain things that people are asking about, water features and fountains, pool sweeps and equipment, those are, as you'll see when we get to paragraph 9, those are listed as always included. And that's one of the reasons why it's so important not just to read this first section, but to really read through the whole contract, because a lot of this stuff is going to be covered further down. So we'll get down to paragraph 9 and you'll see some of those things that come up, like water fountains, like pool sweeps and pool and spa equipment, and those will be in there. And then of course, if there's anything that is typically included and the buyer does not want them, they want it taken away by the seller, that can be listed as excluded there. Last section of negotiable terms here, paragraph Q, allocation of costs. This was the old paragraph 7 in the old version of the form, where you lay out who's responsible for bearing the costs of various fees that have to be paid in connection with the transaction.
So Nhd report, buyer or seller or both. One new note that I really like here for clarification purposes is at the top of this paragraph in the middle of that middle column, who pays. If both is checked, cost to be split equally unless otherwise agreed, which I think people sort of had always defaulted to, but it's good to have that there so it's clear. If you check both, the parties are agreeing to a 50-50 split unless they write in a different arrangement. So Nhd reports, there's also, you'll notice here in Q2 and 3, there's a space to write in other reports that the buyer might want the seller, for example, to provide. So this is where you could write in pests inspection or report or other sort of inspection or report that the buyer is asking for the seller to pay for and provide to them. You'll notice that there's no room to really write in anything else. It used to be that people would sort of like try to squeeze in that, oh, they want a termite report and they want termite section 1 work and clearance. That's really not going to work on the form the way it's set up here. Doesn't mean they could not write additional requests down at the bottom, paragraph R, other terms. There is still a blank line for parties to write in additional requests they have, but this section is really just about allocating costs for inspections or reports, not for any work to be done. Smoke alarm, carbon monoxide detector, water heater bracing. We already talked about the time period for getting that done. This says who's going to pay the costs. Then we have allocation of costs for potential additional government required point of sale inspections and reports or corrective and remedial actions. People get really sort of turned around about this requirement. It can be a little bit complicated. Basically, the smoke alarm, carbon monoxide detectors, and water heater bracing are the only statewide requirements for what has to be done when the property is sold. It's possible that a locality has additional local point of sale requirements that says whenever the property is sold, a certain inspection has to be done or a certain action has to be taken. And this is where you can negotiate for who's going to be responsible for paying for that. The mechanics of how that works will be described in a later paragraph. The rest of these are sort of your standard transactional fees and costs, escrow fees, buyer or seller both split or each to pay their own fees. That's another sort of commonly written in option that there's now a checkbox for. And there's a place here to identify who the escrow holder will be. And then same thing for title insurance policy. Who's going to pay for the owner's title insurance policy, buyer, seller, or both? And then you can identify the title company if that's different than the escrow holder. Now, there's a second breakout section here, default for the buyer's lender title insurance policy. As most of you are probably aware, when you get title insurance, there's two policies issued: an owner's policy that benefits the owner of the property and a lender's policy that benefits the buyer's lender. That cost for the lender's policy is going to default to the buyer, essentially because it's a cost of them getting their loan. Then we have city and county transfer taxes and fees. Another section here that doesn't have an option for checkboxes is HOA documents. So by law, sellers obligated to provide the HOA documents, so it defaults to them bearing the cost and the responsibility for ordering those and paying for their preparation. But if the HOA charges to prepare an HOA certification, which is typically required by buyer's lender, that's going to be a buyer cost since it is typically for buyer's lender. If HOA has a transfer fee, that can be negotiated for buyer, seller, or both. But there is a clarification that says unless the parties agree otherwise, if there's a move out fee, the seller will pay that. And if there's a move in fee, the buyer will pay that. So essentially bearing their own cost. And that applies, if it's separately billed or itemized with a transfer fee, each party essentially bears their own costs. Then there's some other catch-alls. If there's a private transfer fee in a development, who's going to pay for that? And then any other fees or costs. And then final cost to be allocated is the cost of a home warranty plan. So that can be paid by the buyer or the seller or both. Commonly, the seller pays for a home warranty plan. And then, but there is lists a cost not to exceed. So they'll pay for a home warranty plan up to a set dollar amount issued by a particular home warranty company. If the home warranty plan that the buyer opts to receive exceeds the amount that the seller agrees to pay, then, as discussed further down in paragraph 10C, the buyer will bear that cost of any excess charges. Could 16 or 17 be used for termite clearance? They could be. I still would encourage writing in other terms just to be very specific about what the seller's obligation is going to be. I don't want to leave any room for confusion about who's paying for what. But yeah, you want to make sure that you're allocating specifically who's going to pay for those fees or costs. You can put it in 16, 17, but since there's not a lot of room, R is another good option. And yeah, question 14, if it's left blank, it's not allocated to one side or the other, then each side is bearing their own fees by default.
Paragraph 4 is where you indicate which addenda or advisories are attached to the contract. So paragraph 4A here is new, property type addenda. So one significant thing you should know about is that there are 2 purchase agreements that are being removed from the library. There has been in the past a standalone probate purchase agreement and a standalone manufactured home purchase agreement. But both of those contracts were basically identical to the RPA with maybe one additional paragraph or just a couple of additional terms. So instead of having a standalone contract that duplicates the RPA and adds just a little bit of information, then what we're going to do now is people who are doing a probate transaction or buying or selling a manufactured home will use the RPA and will simply attach the addendum to add the terms for a probate sale or add the terms that apply to a manufactured or mobile home purchase. So hopefully that'll simplify things a little bit, not having to juggle and use different forms. Everything will be on the RPA. If it's a probate sale, you'll attach the probate agreement purchase addendum. And if it's a mobile home sale, manufactured home, you'll attach the manufactured home purchase addendum. And some other addenda, we already talked about the tenant occupied property addendum that should be checked whether current tenants will remain or not. And then if the property is a tenancy in common purchase or a stock cooperative purchase, there are addendas for that as well. Those are much rarer, but they do come up, occasionally different forms of purchasing the property. So those were created basically because there was some demand for it. How do you clarify in the contract that they're purchasing into a stock cooperative or that it's going to be a tenancy in common? You would do that by checking those boxes, attaching those addenda. Good question about the vesting issues. Yeah, let me say this. You're not going to be giving your client legal advice about what it means to be purchasing into those types of provisions. There's still all kinds of advisory language, and you should still always be advising your client to seek the appropriate legal advice if they're going to go down that road. But there's just certain properties where the contract needs to clarify, hey, this is a tenancy in common. You're purchasing into a stock cooperative. Those addenda will just allow that to be in the contract. There are, of course, the other addenda. These are pretty much all pre-existing that you might be familiar with. There's a place to add a blank addendum, just addendum number 1, if you need more space and you have additional terms you want to include. If you know you're submitting the offer to be in backup position, you can attach the backup offer addendum. If the property is on septic or well water or is in a rural area where there's concerns about boundary lines, property monuments, and now propane tanks, that can all be included in the SWPI so that the parties address any potential issues with septic, well, property monuments, and propane tanks. If it's a short sale, there's a short sale addendum, sold pursuant to court confirmation. And then if buyer or seller is doing a 1031 exchange, there's forms for that as well. They have slightly changed titles. The buyer intent to exchange addendum or the seller intent to exchange addendum. Those can be attached also. And then last section, dealing with documents attached to the contract. This is various advisories that you typically will be providing to your client in connection with a transaction. You'll notice 4 of them come pre-checked. That's because those 4 come pre-attached to the contract. So when you pull this contract up in your various forms libraries, you will see these advisories attached. We already talked about the agency disclosures that come attached, but you'll also see up front the Fair Housing and Discrimination Advisory that advises both buyers and sellers about their rights and responsibilities when it comes to fair housing laws. The Wire Fraud Advisory, a very, very important form that informs parties how to protect themselves from potential wire fraud, what to be on the lookout for so that they don't get caught, whether it's an email phishing scam or something else that tries to trick them to wiring funds to the wrong account. The Wire Fraud Advisory tells them how to protect themselves from potential instances of wire fraud. And of course, the Buyer Inspection Advisory, which advises buyers, you really should do a number of inspections. Here are the inspections that are available to you. And then finally, the California Consumer Privacy Act Advisory, required by a law, the California Consumer Privacy Act, that basically advises parties that they have certain privacy rights when it comes to their personal information. Then there are additional boxes that can be checked depending on how applicable it is to your transaction. The SBSA, the Statewide Buyer and Seller Advisory, very fantastic form that is encouraged to be used in all transactions, doesn't come pre-checked because it is an additional 14 pages on top of the 16 pages of the purchase contract. So you don't need and probably don't want to attach it to the contract itself, but absolutely should still be providing it to clients for their own information. And then there's advisories as well. If it's a short sale, probate, REO, bank-owned sale, if it's a property being sold by a trust. And then one of our newer forms, the Wildfire Disaster Advisory, if the property being sold is in an area that has been subject to recent wildfires, that is now, unfortunately, a pretty huge portion of the state, then would encourage using the Wildfire Disaster Advisory just so that buyers are aware of the risks of wildfires and certain due diligence they may want to do if that is understandably a concern for them. Well, now that we're at paragraph 5, really this is where we start to get into sort of what I was describing as the explanations, the really important information. We talked about timeframes up in the grid, but then this is where a lot of the questions that you had about how these procedures are going to work, this is where those questions are going to be answered. So we already talked about how the initial deposit works, should be delivered directly to escrow holder. I mentioned if a method other than wire transfer is specified and that's unacceptable to escrow, then escrow holder can give notice and tell the buyer they have to do wire transfer. We talked about increased deposit also, going to be provided in the same manner as that initial deposit. If the party's initial liquidated damages, which is all the way down at the end of the contract, we'll get there eventually, then they also agreed that the increased deposit will be incorporated to liquidated damages. And that's when that DID, delivery of increased deposit form, comes into play. Everybody signs that. And the increased deposit is part of liquidated damages, just like the initial deposit. All right. Important note here in paragraph 5A3, this language has been in the contract for a while, but it's moved a little bit higher, and it's really important for the parties to understand, which says paragraph 29, which is the liquidated damages paragraph. If the parties initial that, it specifies a remedy for buyer's default. What that paragraph will say when we get to it is that if the buyer breaches the contract, the seller is entitled to keep as liquidated damages the deposit actually paid. Buyer and seller are advised to consult with a California real estate attorney before adding any other clause specifying a remedy, like making a deposit non-refundable for buyer's failure to complete the purchase. Those clauses can be deemed invalid or are deemed invalid unless they independently satisfy liquidated damages law. Basically, this is just warning buyers and sellers both to not count on just writing language into the contract that says deposit not refundable. Those sorts of clauses are generally not valid, not enforceable. There's a reason why the liquidated damages clause is written like it is. It's because it meets the statutory requirements, and any attempt to write something different may not be enforceable. If the parties want to go that route, they can have an attorney draft something custom. Otherwise, paragraph 29 is what's going to govern what happens with the earnest money deposit. All right, paragraph B here, there's a note about the all cash offer. I mentioned this up top as well. If you check the box saying that this is an all cash offer, then no loan contingency, and buyer has to provide upfront proof of funds that they have the cash on hand to close the deal. All right, loans. Loan defaults to conventional unless one of those other boxes is checked. Same thing about the additional financed amount. Here is the new provision that I really want to highlight because I think this is important and I think it's going to make sellers and listing agents pretty happy. Paragraph 5C3, buyer's loan status. Per this paragraph, buyer authorizes seller and seller's authorized agent to contact buyer's lender to determine the status of any buyer's loan specified up in paragraph 3, or any alternate loan buyer pursues, whether or not it's a contingency of the contract. If buyer changes lenders, then buyer shall deliver the updated contact information within 1 day of seller's request. So basically what this is saying is buyers authorizing seller and their agent that they can contact their lender and get updates on how the loan is proceeding. This is going to be really important. You know, if the buyer is saying, my lender just needs 5 more days, I just need a short extension, this way the seller or their agent can contact the lender, try to get some confirmation of that, and the seller can make an informed decision. And similarly, it obligates the buyer. If the buyer switches lenders, they need to let the seller know that and provide the updated information so the seller can stay on top of that as well. This is, I know, a big headache, especially these days in transactions. Buyers need to switch lenders. Sellers are frustrated by not knowing what's going on. This allows the seller to stay on top of the loan process. All right, FHA VA loans. We've pretty much covered this already. This is where it says that if the FHA or VA box is checked up in paragraph 3, that a mandatory clause we've been talking about will be incorporated, shall be incorporated, and signed by all parties. And then, of course, we mentioned that buyer has 17 days to deliver seller notice, now using the RR form or the amendment form if they desire. Provide notice to seller of any lender requirements that buyer wants seller to pay for or correct. Or buyer should also notify seller if there are no lender required repairs. Let them know that as well. Of course, notwithstanding seller's agreement that buyer may obtain FHA or VA financing, seller has no obligation to pay or satisfy any or all of lender requirements unless they agree in writing. So simply accepting an FHA or VA offer does not mean the seller now has to take care of those lender required repairs. Obviously, the seller, they hopefully are going in and they know, that this is a possibility, but they're not necessarily obligated. It remains negotiable. We talked a little bit about balance of purchase price and down payment. I guess maybe obviously it needs to be deposited with escrow holder based on escrow holder's instructions. And then this paragraph 5E, this also is a holdover from the old contract, but it's really important, and I think it has gotten missed by a lot of people historically, which is any credit to buyer from any source for closing or other costs that are agreed to by the parties has to be disclosed to buyer's lender, and the credit has to be provided at close of escrow. So the credits have to be disclosed to the buyer, and have to be disclosed to buyer's lender, and they have to be provided through escrow at closing. If the total credit allowed by the buyer's lender is less than what the buyer has been promised, then the credit going to the buyer is reduced. So let's say seller agrees in the contract to give buyer a $7,000 credit for closing costs, and it turns out closing costs are only $5,000, and that's what the lender caps the credit at. The buyer is limited to receiving the lender allowable credit. Again, no credits outside of escrow, no credits behind the lender's back. All credits have to be done through escrow with the consent of the lender and subject to lender approval. So, that's kind of always the case, but it's really important. You don't want a buyer to be disappointed where they think they're going to get a certain amount of money and then they're confused because the lender put a limit on it. It's really important, if you're, say, a buyer's agent, check with the lender ahead of time. Check with the lender as early as possible. Hey, what is the maximum amount of credit you'll allow? You don't want to get your buyer's hopes up and negotiate for a larger credit than they end up being allowed to receive. A couple of additional financing terms. We mentioned this up front. Buyer has to provide written verification of their down payment and closing costs. It can be done either independently by them or by their lender or loan broker. So that's a question I've gotten sometimes, which is, well, what if buyer's pre-qualification or pre-approval includes a proof of their funds for down payment? Then that's fine. That's covered. The buyer doesn't have to provide that information if it's included with the information coming from their lender or loan broker. And then verification of loan applications. We talked about this. They are going to provide that verification that they are pre-qualified or pre-approved for a loan. If it's an adjustable rate, it'll be based on the qualifying rate. Final paragraph about the terms of the financing, buyer stated financing. So this is a big one because this is a common issue where sometimes the buyer writes up an offer and says they're going to obtain a certain type of financing, and then they choose to pursue a different type of financing could be any number of reasons. So this paragraph lets both parties know that the seller is relying on buyer's representation of financing that was specified in the contract, whether that's all cash, down payment amount, loan contingency, and that seller agreed to the terms of this contract based on buyer stated financing. And buyer remains obligated to pursue the financing specified in this agreement, even if they elect to pursue an alternate form of financing. So basically, the buyer writes a cash offer and then interest rates are great and they want to get a loan. You can't really stop them from trying to get a loan, more or less, but they better be prepared to close with cash if that's what needs to happen. Or if they wrote up a traditional, conventional financing and they want to look into getting FHA, VA, they can look into alternate financing, but contractually, they need to be prepared to pursue and close with the financing they wrote into the contract. Seller has no obligation to cooperate with buyer's efforts to obtain any financing other than described in this agreement, but buyer can't interfere with closing at the purchase price on time, even if it's based on alternate financing. So basically, again, what does that mean? It means that the seller does not have to make any accommodations. They don't have to do any extensions. They don't have to allow additional access. They don't have to really go out of their way to help the buyer, assist the buyer in getting financing that wasn't written into the contract. But at the same time, the seller can't refuse to close simply because the funds are coming from a different place than what the seller had been told. So let's say the buyer writes an all cash offer, but then they are able to go out and they get a loan and they successfully get it, and the lender is going to bring funds into escrow to close on time. Well, at the end of the day, if the full purchase price makes it into escrow on time to close, seller's got to close as long as the buyer has performed. Closing in possession. Speaking of occupancy, this refers back to 3E3. Buyer intends to occupy the property as indicated, either primary residence, secondary residence, or not at all. It's an investment property, reminding the buyer that occupancy can impact the available financing that they have. And then condition of property. Couple of key changes in here. Always a lot of questions about what is the buyer entitled to receive at closing? What condition does the property need to be in? So unless anything else is agreed separately, the property is delivered as is in its present physical condition as the date of acceptance. Of course, there could be otherwise agreed. The seller could have agreed to do repairs on the property, but delivered as is as of the date of acceptance. But the seller has to maintain the property in substantially the same condition, including pool, spa, landscaping, and grounds as applicable. Also, any debris or personal property not included in the sale has to be removed by close of escrow or the time possession is delivered to buyer if it's not the same date. So basically, seller can't leave their junk behind. They have to remove all personal property that was not negotiated to be included in the contract. And that needs to be out of the property by closing, or if there's going to be a delayed possession, by the date possession is turned over. Now, here's a new section that's really important, especially for sellers to understand. If items are not removed when possession is delivered to buyer, all items shall be deemed abandoned. And then buyer, after delivering to seller a written notice to remove the items within 3 days, can have such items removed or disposed of and potentially bring legal action against the seller if that ends up costing them any money. So seller can't just leave stuff behind. If seller leaves stuff behind, buyer can send them a notice, just a letter that basically says, you have 3 days to come get these items. If they don't get those items, the buyers can, if they're small, trash them themselves. If they are bigger items and the seller or the buyer needs to pay to have the items removed or disposed of, they could do that and then charge the seller and potentially take legal action against the seller for the cost associated with having those items removed. So really, really important for the seller not to use the closed property as short-term storage. They need to get their items out on time or they risk losing their personal property. Language down here in bold, some more advisory language. Because the property is sold as is in its present condition as of the date of acceptance, the buyer is strongly advised to conduct investigations of the entire property to determine what that condition is. Yes, the seller is going to provide disclosures and the agents are going to do their visual inspection, but even the most diligent seller and agents may not be aware of all defects that affect the property or other factors that buyer might consider important. Property improvements may not be built to code or in compliance with current law or have had all required permits issued or finalized. If the seller has knowledge of any of that, of course the seller is going to be disclosing if they know that there's missing permits or something wasn't built to code or in compliance with law. But sometimes the seller doesn't know, depending on when and how they acquired the property. So very important for buyer to do their due diligence and satisfy themselves with all of those issues. Some notes on seller remaining in possession after close of escrow. We've already talked about how you negotiate that, the different forms you use, how you change the timing. So really what this paragraph is doing here is it really operates as some major advisory language, some major sort of warning language to both parties, really saying, okay, if you're going to do a rent back, if the seller is going to remain in possession after closing, then both parties should talk to their insurance about how this could affect their insurance coverage, and talk to attorneys as well. They should definitely the buyer should talk to their lender about the impact of the seller renting back. We've mentioned a couple of times that we say whether this is going to be a primary, secondary, or investment property for the buyer, because that affects their financing. So their lender needs to be aware of that. And then finally, they are advised to consult with a qualified real estate attorney in the location where the property is to determine basically potential landlord-tenant issues. Now more than ever, landlord-tenant law is extremely complicated. We get a lot of questions about what happens if the seller rents back and then they don't leave, and can the buyer evict, and what are the laws? And you do not want to be in the position of giving your clients legal advice about the current state of landlord-tenant laws and how evictions work and what protections may or may not apply to a seller who stays back in the property. So, now more than ever, strongly advise both sides to consult with a local landlord-tenant real estate attorney so that they can address those concerns. Paragraph 8, contingencies and removal. So just like all the contingencies were grouped together up in paragraph 3L, all of the contingencies are now grouped here in paragraph 8 to really explain beyond. We already know what the time frames are for the contingencies, but this section is really going to explain what rights the contingencies give to the buyer and how these contingencies can be exercised in the contract. So, as we've discussed a few times, this agreement, unless of course otherwise agreed, is contingent upon buyer obtaining the loan specified. So that's why I said it was so important to write those terms up in paragraph 3. What kind of loan, conventional, FHA, what dollar amount, what interest rate, so that it's contingent on the buyer getting the loan that they can afford and want to obtain. If they have that contingency, buyer needs to act diligently and in good faith to obtain the designated loan. So again, that's the risk of the buyer changing financing halfway through, is if they say they're going to get a conventional loan and they switch and get FHA or VA instead, that could impact their ability to potentially cancel based on a loan contingency if they did not act diligently to obtain the loan they actually specified in the contract. Now, important clause in bold here. It's so important, it's actually going to be repeated a few times throughout this paragraph. But if there is no appraisal contingency, or the appraisal contingency has been waived or removed, then failure of the property to appraise at the purchase price does not entitle buyer to exercise their cancellation right pursuant to the loan contingency if they're otherwise qualified for the loan and can satisfy other loan requirements. So it has for a long time been a common misconception that, well, you can just waive the appraisal contingency, because if the appraisal comes in low, you can't get the loan, and then you can cancel based on the loan contingency. But that is not how it works, and it's really important for buyers to understand that these contingencies are distinct. The appraisal contingency is for if the property fails to appraise and basically the property doesn't qualify for the loan. But the loan contingency is really about buyer's personal qualification. So whether the buyer, if they have enough reserves, if they have enough employment history, if their tax records come in, there's all kinds of issues where the buyer themselves may be denied the loan. And if that happens, that's what the loan contingency is for. But if the buyer is otherwise qualified and the only reason they can't get the loan is because of the appraisal, and that is not a loan contingency issue, that's an appraisal contingency issue, and they better have that appraisal contingency. Otherwise, if they can't close, their deposit's going to be at risk. A couple of other notes about limitations on the loan contingency. For example, something like insurability. The buyer needs to investigate the insurability of the property. Can they get fire insurance? Can they get flood insurance? These are becoming really tricky questions for certain properties in certain parts of the state. And it may be a lender requirement. The lender may say, we won't give you the loan unless you have certain fire insurance coverage or flood insurance coverage. But buyer's ability to obtain that insurance is part of the buyer's investigation contingency. It's not part of, again, it's not about buyer's qualification for the loan. So if buyer can't get the insurance, they can cancel based on their investigation contingency, but again, not fall back on that loan contingency. And that had always been kind of a confusing point, I think, for people. So it's really good to have that spelled out here in the contract, but that is a separate investigation issue. Similarly, another important distinction is that the loan contingency is about the buyer being approved for the loan amount. Buyer's contractual obligations to bring in the deposit and the balance of down payment or closing costs are not covered by the loan contingency. So if the buyer is counting on a third party to bring in those funds, or, sometimes buyer's going to be pulling money out of an investment account or something like that, as soon as they write into the contract that the deposit amount is going to be X dollars and the down payment is going to be X dollars, that is a contractual obligation that says that they need to be able to come in with that money. And if something goes wrong, but they're otherwise qualified for the loan, it's not going to be a loan contingency issue, unfortunately. Another reminder that appraisal and loan contingency are distinct. And then paragraph 5, just can't remind buyers enough that if no loan contingency is checked and buyer's getting a loan, seller may be entitled to buyer's deposit or potentially other legal remedies. Okay, a couple notes on the appraisal contingency. This agreement is by default contingent on the appraisal at the purchase price or the dollar amount specified up in paragraph 3 without requiring repairs or improvements to the property. So that's a key addition here, which it says the appraisal needs to come in at value without repairs as a condition. So it's contingent on the appraisal coming in at value as is. However, something a buyer should be on the lookout for that sometimes is raised by appraisals is sometimes the appraisal comes in at value, but maybe the square footage listed in the appraisal is different than what the buyer believed the square footage to be. But if the appraisal comes in at value, that new information does not fall under the appraisal contingency. That again goes back to the investigation of property contingency. So if the buyer discovers new information, they can cancel based on that investigation of property, but the appraisal contingency is solely limited to the value, not to other elements like here's some new information about potential square footage. So something very important for buyers to keep in mind. And then finally, another new clause to be aware of, for any cancellation based on this appraisal contingency, buyer shall deliver a copy of the written appraisal to the seller upon request. So basically, if the appraisal comes in low and the buyer says, I'm canceling based on the appraisal contingency because the appraisal comes in low, the seller does have the right to say, you need to show me the appraisal. And so they can basically verify that and not take the buyer's word for it and say, please send me. And the seller may not want it. They may not care. They may believe them. But if the seller asks, then the seller is entitled to receive a copy of the appraisal to make sure that the cancellation is valid. These issues on the title report, part of their due diligence process, could have to do with documents, deeds, plotted easements, things like that. The important thing to really know here, and this is new, is in paragraph 8E2 here. Buyer has 5 days after receipt to review a revised preliminary report, if any, furnished by the title company and cancel the transaction if that revised report reveals material or substantial deviations from previously provided preliminary report. So what does that mean? That means that if the buyer gets a preliminary report early on and everything looks good, and maybe the buyer removes the contingency because they're satisfied, that's great. But if halfway through escrow, a new preliminary report comes out and now a loose pendant has been recorded, or now a new issue has popped up on title, then if there is, a material or substantial new piece of information, the buyer is entitled to cancel the agreement and receive their deposit back. It basically reopens a cancellation right, and it's 5 days from the date. So if you remove the contingency and now you get a new title report, there's a 5-day window where the buyer, if there's a real problem on that report, could cancel and get the return of their deposit.
HOA docs, if applicable, that's a contingency. Buyers has the right to review the HOA documents that the seller has to order and pay for. And if there's any issues in the HOA documents, then they can cancel if they have that contingency. And yes, the title report is basically a passive cancellation, right? So essentially it's a 5-day set window. It doesn't reactivate the contingency. Great clarification question. If the buyer gets that new prelim, set 5-day report, then they can cancel. Buyer review of leased or liened items. There was a question about this earlier. Buyer's review of and ability and willingness to assume any lease, maintenance agreement, or ongoing financial obligation, or to take the property subject to a lien, is a contingency. So this comes up most often in solar issues, solar leases, and there's other types of PACE and hero liens and things like that. Basically, buyer has a contingency to decide if they are willing or able to take on the property subject to those issues. They can ask for the seller to resolve or clear those items, but the seller is not obligated to. Basically, if the buyer doesn't want to take the property subject to a solar lease or other type of lien, then they could cancel. And really, it is up to the buyer. And if they remove that contingency, they would be considered obligated to move forward and do what is necessary to take the property subject to those leases or liens. And there's any assumption of the lease will not require a financial obligation or contribution by seller. Seller does not have to chip in to resolve any of those issues. And in fact, if the buyer says they're not going to enter into necessary written agreements, if they won't sign a new solar lease, if they won't sign any documents to take on these financial obligations, seller could actually give a notice to perform and cancel. And could always just say, sorry, buyer, you're not committing to taking on the property subject to this solar lease, potential notice to perform and cancellation. If the seller did that, they're canceling based on the notice to perform, buyer would get their deposit back, but that would end the transaction. So we've already talked about the risks of removing or waiving contingencies with the offer. But what this lets the buyer know is the buyer they're not obligated to remove these contractual contingencies unless they've received all of the required documents, reports, and disclosures and information that they're entitled to. But if the buyer does remove a contingency when they haven't got all those documents yet, they're relinquishing any contractual rights that apply to that contingency. So let's say the buyer doesn't have the HOA documents yet and they waive the HOA document contingency, then that's, they're waiving that right. They're saying, I'm willing to take that risk. I don't care what's in the HOA documents. I'm committing to close. I'm removing that contingency. Now, there's different rights associated with late disclosures from the seller, a late delivery of a TDS, a late delivery of an SPQ. We mentioned that a little bit earlier, and we'll talk about it shortly after the break as well. So there's some protection for the buyer if some brand new information is dropped on them by the seller late into a transaction. But if the buyer knowingly waives a contingency, sort of knowing that there's something like an HOA document they haven't received yet, then that they are taking on that obligation and saying they're going to close no matter what. And that's why it says if the buyer removes or waives any contingencies without an adequate understanding of the property's condition or their ability to purchase, buyer is acting against broker's advice. You always want to make sure you're advising your buyer to protect themselves, maintain their contingencies if at all possible. A couple final notes here. As far as removing the contingency or potentially cancellation, for any contingency, buyer is obligated to remove the contingency or expected to cancel. We talked about how for the seller documents and those additional reports, buyer has that time period or 5 days after receipt to remove the contingency. What happens if the buyer doesn't remove the contingency? Well, then seller can give a notice to perform and they can cancel the agreement and return buyer's deposit. So we still have active contingency removal. Those contingencies still stay in place until they are removed. And if the seller is frustrated with the buyer refusing to remove contingencies on time, that's when the notice to perform and cancellation process comes in. And we'll talk about that more after the break as well. Final contingency, if the buyer is buying contingent on the sale of their current property, that needs to have been established up in paragraph 3L8. Otherwise, this default language says that the agreement and buyer's ability to obtain financing are not contingent on the sale of any property unless they've checked the box agreeing otherwise.
And now we are in paragraph 9. A lot of stuff to cover here about what items by default are included or excluded from sale. So there's a really important note here up at the top, which is that basically reminding buyers and sellers that just because items are listed as included or excluded in the MLS or other marketing materials, or even in some of the disclosure forms, that does not mean that those items are included in the purchase price or excluded from the sale unless specified in the contract itself or is otherwise agreed. So basically what you want to watch out for is sometimes the MLS will state appliances included. Great, that's a great thing to know, but that still means that the contract should confirm that. The contract should reflect the actual agreement between the parties as opposed to MLS listings or flyers or marketing materials. So if a listing states that appliances are included, then you should expect the seller to be totally fine with an offer that states appliances are included. Make sure the corresponding boxes are still checked up in paragraph 9 for any items that the buyer wants to include. And similarly, even if in the marketing materials the seller states that certain items are excluded, that needs to be either in the buyer, if they see that in the marketing, could write it into the contract themselves, or the seller needs to be mindful to do a counteroffer to exclude any items that they don't want to have included, because there's quite a few things that are included with the sale as it is. So, and this also has the language that I know somebody asked about earlier, which is any items included herein are components of the home and are not intended to affect the price. So essentially, no additional value. Any items that are included, that is included with the purchase price, and there is no independent value associated with them. And all items are transferred without seller warranty, except we'll get a little bit further down. There is language further down in the contract that says that if there are transferable or, transferable, I guess, warranties, the seller will provide those. But there's no requirement that the seller go out and obtain or basically promise that these items are going to work forever. The seller themselves is not providing any warranty. If they have any manufacturer's warranties, that can and should be provided. All right. So all of that preamble being done, what items are actually included in the sale? Well, all existing fixtures and fittings that are attached to the property. So that's kind of the standard rule. If something is affixed to the property, if it's built in, if it's bolted in, that is considered a fixture and it conveys with the property. So, there's a whole legal standard of what constitutes a fixture, but a good way of thinking about it is if you would have to damage the property to take something off of it, then it's a fixture. And if it's attached in a permanent way, or a way that was intended to be permanent, that's a fixture. And even if it's not mentioned anywhere else, that sort of item is included and conveys with the sale. But there's all kinds of additional items that are included as well. Some of which I think may be very surprising to the parties. And so it's really important to read this paragraph carefully with both your buyer and seller clients, so they know what they're getting. And especially if you're representing a seller, really important to have them read this paragraph, because if there is something in here that they don't want to include, they're going to need to counter it out. So, some of these things are a little bit more obvious than others. Any existing electrical, mechanical, lighting, and plumbing and heating fixtures. Ceiling fans is a big one. If the seller has a really fancy ceiling fan they love, that's included unless they specify otherwise. Fireplace inserts, gas logs and grates. Solar power systems. So that's one of the reasons why all that language about leased and liened items is so important, because if there are solar panels, by default, the seller says, hey, solar panels are included. I own those, you can have them. They need to disclose if they don't fully own those solar panels, so that the buyer can decide what to do about that. If the appliances are built in, or if they had special openings or encasements constructed for them to be installed into, then those are automatically included, even if not checked in 3P. So if you have built-in appliances that are affixed to the property that you couldn't just unplug and wheel away, or if they are sitting within a specially constructed cabinet or encasement of some kind, those are automatically included. Windows and door screens, awnings, shutters, window coverings. So this language about window coverings being included in the contract has been here for quite some time, but it's often caused a lot of confusion. And we've gotten a lot of questions for what does window coverings mean? Does that really mean curtains and drapes? Well, now the contract specifies. It includes blinds, curtains, drapery, shutters, or any other materials that cover any portion of the window. So that is very broad. And a lot of sellers have that sneak up on them. They don't really think about the fact that when they sell the property, they're selling it with the drapes included. So if these are drapes that the seller wants to keep, that they have some sort of sentimental attachment to, or they just feel like they're their personal property, then they can take them down in advance of selling the property. That's one option. Or if they are up, they can counter those out and say, no, actually, window coverings are not included. Attached floor coverings, television antennas, satellite dishes, Here is a clarification that I had somebody ask about earlier. Pool spa equipment, which it now used to just say pool spa equipment. Now it actually says including but not limited to any cleaning equipment such as motorized or automatic pool cleaners, pool nets, pool covers. So seller cannot take the pool sweep, can't take the pool cover, even the nets or other devices for skimming the pool. Those stay with the property. So seller's obligated to leave those behind. Garage door openers and remote controls, in-ground landscaping. Here's your language about water features and fountains, water softeners, and water purifiers. So any of those sort of water-related items, whether it's decorative water features and fountains or installed practical water softeners and water purifiers, those stay with the property. And a new one that was added in here for this version of the contract is light bulbs, including smart bulbs. So sellers cannot unscrew and take with them the light bulbs. Those stay behind, even if they are some kind of fancy smart bulb situation. Those are included unless the sellers counter them out. And then also, of course, incorporating all those items we talked about up in paragraph 3P already, your additional appliances, your smart video doorbells, things like that, if currently existing at the time of acceptance. So that's a question that happens sometimes where someone will check a box saying that, washer and dryer are included, but and then it turns out there is no washer and dryer in the property at all, and there never has been. Well, this is limited to items existing at the time of acceptance. So if you're going to ask for something, the seller does not have to go out and buy you a new one if there wasn't already one present on the property. It's including any existing items with the sale. As I've mentioned a few times, if the seller does not want to include any of these items, especially if it's because it's not owned by the seller, like maybe the property is staged, that has come up a few times where the stager put up fancy curtains, then it's really important, for the seller to counter those items out and make it clear that they have to exclude them. They don't have the right to convey those items. They don't belong. And that can be done either up in paragraph 3 with items excluded, or it can be done in a counteroffer. There's a couple of explanatory sections about some of the items listed in 3P, like what is a security system? What does that include? It includes basically any devices, hardware or software that can be used to monitor or secure the property. Could be motion detectors, alarms, other equipment. If the box is checked in 3P, those are included. Same thing with home automation systems, which could be a fancy thermostat of some kind, a fancy smart appliance, any of those connected smart utility appliance home features, those convey with the property if they're checked up in 3P. And then the parties are further advised that they might want to use an additional addendum to more directly clarify what items need to be included, and the seller can counter out anything they don't want. And there's one key caveat here, which is non-dedicated devices. So let's say the buyer asks for a smart home, the smart home system to be included, or the security system to be included. Then often those items are monitored or controlled by a smartphone or a tablet or something like that. No, that does not mean that the seller now has to give their iPhone or their, Galaxy or whatever their smart device is to the buyer as included in the sale. Non-dedicated devices, personal tablets and phones and things that might control these systems, they don't have to provide that. That is their own personal property. Buyer acknowledges that they may need to have an appropriate device and be able to use Wi-Fi or something like that to control those items. Now, seller will provide access, tell them what apps they need. Buyer should definitely set up their own accounts with their own passwords. But that's something for the buyer and seller to work out. If there's one of those items and it's listed as included, then seller provides the means of accessing it, short of having to give over their own tablet or smartphone. And then one more paragraph talking about the leased or liened items, letting the seller know that if any of the items included on the property listed as included, like say solar panels, are not fully owned by the seller, or is subject to an ongoing financial obligation or a lien or encumbrance on the property, then the seller has a disclosure obligation to deliver to the buyer all written materials, could be their lease, their warranty, their financing agreement, concerning any such item. So they, in the disclosure time period, in the first 7 days, seller should be providing that information to the buyer. And that's what the buyer will use to do their due diligence and determine their willingness and ability to take on those financial obligations and continue with the transaction. So other than that, seller is representing that all the items listed above as being included in the purchase price are owned by the seller and will be transferred free and clear of liens of encumbrances. Unless otherwise disclosed, transfer without warranty, will cooperate. Like I said, they'll let the buyer know, here's the app you need to download to run the smart home software, if that's an issue, for any utilities or security systems. And then finally, a couple of items that are specifically excluded from the sale. The biggest one being things like flat screen TVs or surround sound speakers. If they are maybe mounted on the wall with brackets or other things so that it secures them to the wall safely, but they themselves are not bolted in, if they can just be attached to like a bracket. So even if the bracket is bolted in, but you can take the TV off, the flat screen TV does not automatically convey with the property. It could be negotiated, but it is excluded by default. Same goes for furniture or other items secured to the property for earthquake or safety purposes. I mentioned that if something is bolted in, it's considered a fixture. Well, a lot of, tall shelves and heavy furniture items may be bracketed to the wall, not because it's intended to be a fixture to the property, but simply just for earthquake safety, so that if in the event of an earthquake, nothing falls down and hurts anybody. If their furniture is only secured for earthquake or safety purposes, then that's excluded as well. This is a change from the previous version of the contract, which is what happens if there are brackets. So the default option has actually flipped, which is unless otherwise specified up in paragraph 3P1, and there is a checkbox for brackets up there. The default is if the seller has a wall-mounted TV or surround sound system and they're taking down the audio-visual components, that those brackets will be removed and holes or other damage will be repaired, but they don't have to repaint. So if you take down a wall-mounted flat screen TV, the default is, okay, you take the brackets down as well, you patch up any holes, but it may visually look a little funny. There's no obligation for the seller to go back and repaint or match the paint there. Buyer can take care of that. If the buyer wants the brackets to stay, maybe they like the setup and they're going to get their own flat screen TV to put on that bracket, then in 3P1, they can check the box saying that wall-mounted brackets for these sorts of devices stay with the property and remain in place. So allocation of costs. Obviously, it was up in 3Q where we actually had the check boxes for, who's going to pay what and what the splits are going to be. But this really delves into the procedures for how these costs will be split. So like I mentioned before, up in 3Q, at least 1 through 3 and 5, that only determines who's to pay for inspections, tests, or certificates or services. It does not determine who is to pay for any work recommended or identified in the report. So if you just check a box in 3Q2 and say seller to pay for termite report, that in and of itself does not automatically obligate the seller to pay for the the work called out in that inspection report. Agreements for payment of required work should be specified elsewhere, further down in 3Q or 3R, which is the additional terms section, or in an entirely separate agreement, an addendum, an amendment, or of course, that's what the request for repair form is typically used for. So if the buyer wants or needs to ask for the seller to be responsible for certain work, asking for the inspection report in and of itself isn't going to do it. They need to specifically ask the seller, and seller needs to agree to be responsible for any recommended work or clearances. All right. 10B here talks about government requirements and corrective action. So this was the old 7B in the old RPA. And it's very similar, although I think now, I hope at least, that the wording here is clear in a way that will really help, of course, all of you, but buyers and sellers really understand what are the legal obligations, what sort of government requirements apply or don't apply when the property is being sold. So we talked about sort of the easy one for everyone to understand, which is the California statewide requirements, the smoke alarms, the carbon monoxide devices, and water heaters strapped for earthquake safety. Sellers already acknowledged or agreed that those installations will take place within the first 7 days or whatever other time frame is agreed to. If the cost is shifted, so conceivably the seller could say, well, yeah, I know that has to be done, but I don't want to pay for it. Buyer, you pay. So if the buyer's paying for those items, then they'll work out with escrow whether they're going to deposit funds into escrow or pay the vendor directly for completing those repairs or installations. But ultimately it's seller, unless they qualify for an exemption, but most sellers will have to deliver to buyer a written statement of compliance that they've complied with these laws. That is included within the transfer disclosure statement, or you may be familiar with, for example, the WHSD form, the water heater and smoke detector statement of compliance. So most sellers, unless they are, say, an REO seller and qualify for an exemption, have to certify that the property is in compliance with those health and safety issues. So sellers got to give that to the buyer, regardless of who ultimately pays for the installations. If the seller is responsible for paying and doesn't take care of it in the time specified, and that incurs any cost to the buyer, especially if it's to comply with lender requirements concerning those items, sellers are responsible for reimbursing buyer. So if the buyer has to come out of pocket and install these things when the seller contractually agreed to do it and doesn't follow through, seller retains responsibility, even if buyer had to do it just to get the deal to close. 10D2 talks about point of sale requirements. And I mentioned this a little bit earlier, sort of previewed this section, which is that certain localities, certain cities and counties have what are called point of sale requirements. They have inspection. Someone mentioned the LA 9A report. There's various ones around the state. There's not a ton, but there are a few scattered around the state that says when the property is sold, certain inspections or reports need to be generated, and potentially certain repairs or clearances need to be taken care of. So if a point of sale requirement exists in the location where the property is located, then by default, unless they agree otherwise, whatever has to be done, if it's repair work, will be completed prior to the final verification of property, prior to the final walkthrough. If buyer, again, is agreeing to pay for any portion of that, they can pay the vendor directly or provide an invoice to escrow and deal with it through escrow. Of course, if part of this requirement is an inspection report, then buyer's entitled to receive within those first 7 days, the 3N1 timeframe, a copy of the requirement government conducted point of sale inspection report prepared pursuant to the agreement or in anticipation of the sale. So, there was a question about, can't they do it later? I mean, they can agree to do it later if the law allows. But one, you have to be careful that the law allows that. And two, it would have to be agreed specifically in an addendum or a counteroffer or something like that. Otherwise, by default, seller is responsible for getting that report to buyer within those first 7 days, which is a reason why they may want to order that sooner rather than later. Like I mentioned with HOA docs, it's always a wild card if you have a third party, whether it's an HOA or a city, who you're counting on to get you something to close your transaction on time. So definitely encourage to order that as early as possible to make sure the transaction time periods stay on top of everything. And then here's a really great addition. I saw someone sort of flag this earlier, and I think this is hopefully going to resolve what had been the source of some disputes in transactions, which is if one of those repairs called out above, the carbon monoxide, smoke detector, water heater, if that's not done within those first 7 days or the time specified, and it's not done in time for an inspection or an appraisal, and now the lender requires an additional inspection, seller is contractually responsible for the corresponding reinspection fee. That was always I know sometimes a headache for people when these reinspections are required. But seller, if they don't get those inspections done on time, if they don't get those installations done on time, and now there's a cost for doing a reinspection, sending the appraiser back out, seller's responsible for that. And if buyer has to pay that to keep the loan going and comply with lender requirements, seller would be obligated to reimburse them. And then final note here, because this is always the big question that comes about these point of sale requirements, just a note that buyer and seller are advised to seek information from a knowledgeable source regarding what these laws are and whether they're point of sale requirements or requirements of ownership. It's really beyond an agent's area of expertise to be able to advise on every city's and county's local laws. There's all kinds of ways to do due diligence on this. I often recommend, if you have a trusted escrow officer in the area, often it's a escrow officer's job to know what needs to be done in order to close a sale legally. That can be a good resource. Local attorneys can be a good resource. The buyer and seller can, reach out to the city or county directly. Sometimes their websites have good information, not as often as I'd like. And it can be hit or miss trying to reach somebody on the phone. But if there's really no other way to determine it, that's kind of a last resort option. And then finally, the home warranty cost allocation. This is a little bit different than how it used to be, where you would specify the coverages in the contract. Now, it just says that buyer will choose the coverages, regardless of any optional coverages indicated. They can put into the contract, here's the optional coverages I want. That can be written into that section up above. But ultimately, the buyer can choose what sort of coverage they want. And the seller is obligated to pay for it up to the cap that they put up in paragraph 3Q. Otherwise, buyer will pay any amount that exceeds. So if seller says, I'll pay for a home warranty plan up to $300, and buyer chooses a plan with coverages that ultimately are going to cost $350, then buyer is obligated to pay that additional amount, and seller is just limited up to whatever they chose to pay. Or vice versa, if seller says, I'm going to, I'll pay the cost up to $350, and then the warranty only costs $300, then they're only paying the $300. It's just a cap on the most they'll be required to pay. It's possible that the home warranty plan could cost less. If the buyer waives the purchase of the home warranty plan, they are advised that they can still choose to buy one themselves. It's never too late. So the buyer can say, no, I don't think I need one. But if they maybe realize the benefits of having a home warranty plan, they can always, at their own cost, choose to purchase one prior to closing. Paragraph 11 now is where we're going to start getting into the disclosure obligations of the contract and sort of breaking down all the different types of disclosures that the seller is going to need to provide to the buyer in the course of the transaction. You'll see a lot of references to laws and civil codes and things here because there's a lot of legally required disclosures here in the state of California. And this paragraph 11 is going to describe all of the disclosures that the seller needs to provide. So it starts off by referencing again that time period up in 3N1, which is the default 7 days, and listing out which disclosures the seller needs to provide unless they're exempt. And I'll talk about the exemptions a little bit further down. So your standard non-exempt seller needs to provide statutory disclosures, which include the real estate transfer disclosure statement, the TDS, the NHD statement, and then certain other statutory disclosures about release of controlled or illegal substances, mello-roos on the property, notice of special tax assessments, industrial use and military ordinance. Those are all included in the seller property questionnaire or in the exempt seller disclosure for a seller who is exempt from the other disclosures that are required. And then finally, if the property is in a high or very high fire hazard severity zone, then the seller also will provide the new home hardening and defensible space information that is included in the FHDS form, the Fire Hardening and Defensible Space Disclosure, Addendum, and Advisory. And we'll get into that in just a minute here. So paragraph 11A2 specifically describes when the TDS, the Transfer Disclosure Statement, is considered completed. And we previewed this earlier. You guys were on top of this question because it is a very common one, but it's laid out here in the contract as well, which is the TDS is considered fully completed if the seller has checked a box in section 1, answered all the questions, and signed in the seller's information section in section 2. And the seller's agent, if there is one, has completed and signed the seller's agent section in section 3, or even better, attached an agent visual inspection disclosure form. So the TDS is considered complete when sections 1, 2, and 3 have been completed and signed by all the appropriate parties. There's sometimes this question about section 5, which is the acknowledgement at the very bottom. And that often gets signed later because that acknowledgement of receipt should be signed after all the previous sections are completed, including both agents' visual inspections. And so that section doesn't need to be signed for the TDS to be considered complete, but sections 1, 2, and 3 do. The portions that the seller fills out and the listing agent's visual inspection. Now, there's also a note that just because the buyer's agent's visual inspection is not required for the TDS to be considered complete, that does not relieve the buyer's agent from their legal obligation to conduct a visual inspection and make a disclosure on section 4 of the TDS or an AVID form of the material facts that they observe and need to disclose about the property. And it's very important, like I said, for the buyer's agent to do that. It's their fiduciary duty representing their own client. Obviously, a buyer's agent can't do their own AVID at the last second and then think that's going to open up some sort of cancellation right for the buyer. There's no loophole like that. But really, the buyer's agent needs to be doing their AVID, as early as possible, definitely within the time period when the buyer still has contingencies. So if the buyer's agent discovers something because they're very diligent that nobody else spotted, then they want to make sure they get that information to their buyer while they still have time to do something about it. So very important there. All right, and then paragraph 3 talks about the obligation to provide a seller property questionnaire unless the seller's exempt from the TDS. So unless the seller's exempt from the TDS, they will also be providing an SPQ. It's only if the seller qualifies for a disclosure exemption that they will do the exempt seller disclosure instead. So just a brief rundown, the most common exemptions you are going to encounter is if it's a probate transaction, if the seller is trustee of a trust and not like a revocable living trust and they live in the property and just put it there for estate planning purposes, but if they are really administering a trust, typically as a successor trustee, then they're going to be exempt from these disclosures. Also, bankruptcy, court-ordered transactions, or like I said, REO, bank-owned sales, those sellers are all exempt and would only do the exempt seller disclosure. Otherwise, seller is doing a transfer disclosure statement and a seller property questionnaire. And then 11A4 deals with one of the big questions that was coming up, which is what happens if there's new information to disclose during the escrow period. So if during escrow, the seller or their agent becomes aware of some new information or realizes that the disclosures provided were inaccurate or something was left out, then seller is required to provide a subsequent or amended TDS or SPQ or any other written document to cover those items. That's considered an amendment to the TDS or SPQ and absolutely can open up cancellation rights, which we'll talk about a little bit further down. But the big caveat here is that a subsequent or amended disclosure shall not be required for conditions and material inaccuracies of which buyer is otherwise aware or which are discovered by buyer or disclosed in reports or documents provided to or ordered and paid for by buyer. So that circles back to the question we addressed earlier, which is what happens if the buyer removes all contingencies and then discovers new information in their home inspection? Well, if it's a home inspection that the buyer ordered and paid for and it reveals something new, that does not open up a new cancellation right for them. The only thing that opens up a new cancellation right is if the seller decides, I shouldn't say decides, but the seller discovers the new information and provides the new disclosure. Often there will be something revealed in an inspection report that's not in the seller's disclosures because the seller doesn't know about it. They're not inspectors. They may not, have looked into the same things an inspector does. And so that is the importance of that in separate inspection and investigation contingency, is so that the buyer can have a professional do an inspection that is going to reveal all of the important information that may not be included in sellers' disclosures. And again, a little bit further down here, I'll talk about exactly how the cancellation rights work if there is a late or amended disclosure. So we'll get to that in just a couple minutes. Couple other disclosures required by law. Lead-based paint disclosure. If the property was built before January 1st, 1978, then seller has to provide the lead-based paint disclosure form and the lead disclosure pamphlet. And buyer has the opportunity to conduct a risk assessment or inspection for lead-based paint risks. Typically is going to line up with their inspection time period. All right. Now we're going to spend a couple of minutes talking about the newest disclosure laws. So this is brand new to the RPA because this new disclosure law was passed that has been sort of rolled out over the course of 2021. The first part of it, home fire hardening, went into effect in January, and the second part, defensible space, went into effect in July. So this is relatively new disclosure laws and brand new to the purchase agreement. This topic can be a little bit dense and a little bit complicated. I'm not going to go super deep on these requirements. I could spend an entire hour just talking to you about these laws, but we will cover what the seller needs to do and provide time frame wise for these disclosures with this contract. So the first half of this new law has to do with home fire hardening and the disclosure and advisory provided to the buyer. So home fire hardening, if you're new to that term, is basically a series of retrofits that can and really should be done to a property to harden the home, to make the home less susceptible to wildfire, specifically from flying embers. One of the reasons why wildfires spread so fast and wind is so dangerous is wildfire embers can fly up to a mile ahead of a fire, land on flammable material, and spread the fire from there. So homeowners in these fire zones are strongly encouraged to have certain home fire hardening elements installed in the property. So for certain sellers, they are required to disclose whether or not these home fire hardening features are present or lacking on the house. So if a TDS is required, so not exempt sellers again, but if a TDS is required and the property is in a high or very high fire hazard severity zone, typically as indicated on the NHD, and the home was constructed before January 1st, 2010, seller will deliver to buyer the home hardening disclosure, which includes some language about the importance of home hardening and a statement of features that the seller knows, vulnerabilities that exist on the property. And then if a final inspection report regarding compliance has been issued, then they would include that as well. So just a quick rundown, home fire hardening features could include, or let me put it this way, home fire hardening vulnerabilities could include single paned windows instead of double paned, wood shake roofs instead of less flammable material roofs, lots of dry brush and things immediately adjacent to the property. So this disclosure will ask the seller, are you aware of any of these issues? And it does ask, are you aware? So much like the other disclosures, if the seller has no knowledge for whatever reason, they're not exempt, but they really don't know much about the property, they would only check the boxes that they have an awareness of. And just to recap, this applies where TDS is required and the property is in a high or very high fire hazard severity zone. And in this case, if the home was constructed before 2010, because starting in 2010, new construction properties typically come with these home fire hardening features as standard. So it's only the older properties where the seller needs to disclose if these vulnerabilities exist. So that's, it's an additional disclosure, but it is more or less straightforward. The slightly more complicated element is the defensible space portion of this law. So similarly, for any transaction where a TDS is required and the property is located in a high or very high fire hazard severity zone, then the seller has to deliver to buyer a disclosure of whether the property is in compliance with applicable defensible space laws and an addendum allocating responsibility for compliance with those laws. Okay, so a couple of things to note here. One, this applies to all properties in a high or very high fire hazard severity zone and not just, unless they're exempt from the TDS, regardless of year built, because defensible space is different than home hardening. Home hardening is about features present on the physical structure of the house. Defensible space is about the area around the house. So there's two zones consisting of 30 feet and then 100 feet around the property where per existing laws, so these laws are already in effect, people who own properties in these fire zones are already under certain state and local laws that say you need to maintain defensible space around your property so that in the worst case scenario that a fire comes through, it'll slow down the spread. You have your brush and things cleared away. And so you want to make there to be space, defensible space, between the structure and the brush or other flammable materials that exist on the property. So technically, property owners in these areas are already supposed to be complying with this law. What this law does now, the new disclosure requirement, basically says, okay, seller, if you have documentation that the property is in compliance, provide that. Okay, straightforward enough. And then if there's a local point of sale requirement, of which there are extraordinarily few, but if there is a local point of sale requirement, then seller has to comply with that. That'll have been addressed up in the point of sale requirements also. But for most places where there's no point of sale requirement, if the seller does not currently have documentation of compliance, then buyer and seller need to sign an addendum allocating that responsibility, which could be allocated to the buyer post-closing. Under the general state rule, buyer can sign this addendum and say that they will bring the property into compliance with defensible space laws within 1 year after closing. And that's the default basically on this FHDS form, which is if the property is not currently in compliance and there's no local rule requiring the seller to do it before closing, then buyer will agree to take on the responsibility and bring the property into compliance within the allotted time period up to 1 year post-closing of the sale. Paragraph E here is just a note to remind buyers and sellers that those disclosures discussed above are not waivable. Sometimes sellers will ask buyers to waive them or buyers will even offer to waive them. But these disclosures that are required by law, by the California Civil Code, are not waivable. The law specifically says that. So you can't try to waive them. Even if the buyer did say, I don't care, if something comes up later, seller would be liable and responsible for not having provided those disclosures. So it's really in the seller's best interest to make sure those disclosures are completed appropriately. Buyer, of course, on their end is responsible for signing and returning copies of all the disclosures that they receive that are listed up here by the 17-day time period or 5 days after receipt, whichever is later. So the big question that comes up is what happens if disclosures are delivered late or there's some sort of issue with that defensible space addendum that needs to get signed. So if any of these statutory disclosures are listed in 11A, B, or C, so that's going to be, TDS, NHD, SPQ, lead-based paint, and home hardening disclosure, if those are not provided or they are provided late, then the buyer will still have the right to terminate this agreement within 3 days after delivery in person, or more commonly, 5 days after delivery by mail or electronic mail, so email basically, by giving seller written notice of the rescission. And if the buyer does not rescind within that time period, they're deemed to have approved the disclosure and not have the right to cancel. So what does that mean? That means that once you are in escrow, if these documents are delivered, even after contingencies have been removed, this is what can open up cancellation rights for a buyer. So if you are dealing with a transaction where buyers are waiving contingencies up front, these disclosures need to have been provided to them in advance, prior to the signing of the offer, in order for them to really be locked in. Because if any of those disclosures, including the listing agent providing their visual inspection disclosure, are provided during escrow, then it doesn't reactivate the contingency, but it reactivates a small time period, 3 to 5 days, depending on the method of delivery, where the buyer can elect to rescind the contract and say, nope, not going to buy, cancel, get their deposit back. And similarly, although not the same, if the parties can't agree what's going to happen with the defensible space compliance. So if the seller sends it in to the buyer and asks the buyer to sign agreeing to take responsibility for bringing the property into compliance with defensible space laws within a year after closing, or whatever time frame the local rules call for, and buyer doesn't agree, then seller could give a notice to perform and they could cancel. They could say, look, buyer, you have to sign this addendum. This is required by law. It's required by our contract. If the buyer says, no, I don't want to sign that, I don't want to take on that responsibility, and the parties can't work out any other arrangement, the seller could give a notice to perform and say, well, then I'm canceling. So that's a new wrinkle based on this new law and this new form. Buyer needs to sign and return that within the 17 days. And if they don't, seller could give a notice to perform and potentially cancel the agreement. Tax withholding. Not the most thrilling and kind of one of the more confusing elements of the contract, but extraordinarily important to understand and really be able to share and explain to your clients if there becomes an issue with this. So the tax withholding is probably most familiar to you as the FERPTA law or seller's affidavit QS form. The old version of the contract basically was just, this section was 2 lines and said, well, seller, you have 7 days to provide the FERPTA or the seller's affidavit or the QS, and that's the requirement. But there have been so many questions about procedurally how does this work, that this section was really expanded to try to walk through for the parties. Here are all the various options. Here's what might happen and how you can comply with the tax withholding law. So first thing up front, because this is the default under the law, which is that buyer and seller are hereby instructing escrow holder to withhold the applicable required amounts to comply with federal and California withholding laws and forward those amounts to the IRS and franchise tax board respectively. So basically the default, unless one of these other actions take place to exempt the transaction from withholding, is that a certain percentage of the sales price, 10 to 15% plus California tax, escrow holders instructed to withhold those amounts and remit them to the appropriate tax authority unless one of these other options comes into play. So it goes on to say that, however, no federal withholding is required if one of these things happens prior to closing. The first thing that could happen is seller could deliver straight to buyer and escrow a fully completed seller's affidavit, sufficient to avoid withholding. That used to be the norm. It doesn't happen much anymore because a fully completed, legally compliant seller's affidavit form has the seller's tax ID number on it, which for an individual is their social security number. And understandably, most sellers are not willing or eager to fill out a form, put their social security number on it, and hand it to the buyer. They may not know very well or at all. So there is a second option, which is, or the seller can still fill out that seller's affidavit form, but instead of giving it to the buyer, they can give it to a qualified substitute, often an independent escrow company, or if the transaction isn't using an independent escrow company, it can be a title company. Give that affidavit to the qualified substitute instead of directly to the buyer. And then the qualified substitute delivers to the buyer an affidavit signed under penalty of perjury, which is called the QS form, where they say, look, I have the seller's affidavit with all their tax info, and you can rely on that, buyer. And that will avoid withholding as well. And basically it says, or other documentation satisfying requirements. Really the only other option for avoiding withholding is the very rare circumstance where the purchase price of the property is less than $300,000 and the buyer is purchasing it to owner occupy. Then there's a buyer affidavit form that the buyer can sign and avoid withholding. But these days in California, not too many transactions closing under $300,000. So for the most part, either the seller has to fill out the seller's affidavit and provide it to the buyer, or they have to utilize the qualified substitute process. And as long as they do one of those things, then no withholding is required. Otherwise, if they don't do that, or if sometimes they can't do that, if they can't sign an affidavit of non-foreign status because your seller is in fact a foreign person, an overseas investor or something along those lines, then withholding has to take place. Because the way this law is written is that if there's no seller's affidavit or qualified substitute, the deal closes, the taxes don't get paid. Well, that's why the IRS expected the withholding to be done. If the buyer doesn't have the documentation explaining why they didn't withhold, they could be on the hook. So very important to make sure that this procedure, one of these options, is complied with. And this is, it's, like I said, needs the cooperation of escrow. Check with your escrow company, make sure they're willing to act as a qualified substitute. We'll get down to the escrow section in a minute, but our escrow instructions portion of this form does instruct a eligible independent escrow company to act in that capacity. If you're not dealing with an eligible independent escrow, title company is your next best bet. All right, these next two sections, I and J, these are unchanged from the previous contract. These are required disclosures that need to be provided to every buyer. Years ago, they were all standalone disclosure forms, a Megan's Law database disclosure form and a notice regarding gas and hazardous liquid transmission pipelines. But because they are required in virtually every single transaction and not really lengthy, they're just built into the contract themselves. So basically letting the buyer know that the Megan's Law database exists and encouraging the buyer, if this is something that is relevant to their purchase of the property, that they utilize the Megan's Law database and do their due diligence as necessary to satisfy themselves with the neighborhood and conditions of the property. And similar notice regarding gas and hazardous liquid transmission pipelines notifies the buyer that there is a public database where they can look and see if there are potentially, if there are gas or other transmission pipelines underground, if that's something that is concerning to them, tells them where to go and how to seek more investigations or information so they can satisfy themselves with that issue. All right, HOA docs, we've talked about this a few times. Seller has 7 days to disclose whether the property is located in a condo or planned development with an HOA. Buyer probably knows, but it is a required disclosure. And there are questions on the SPQ, the seller property questionnaire, and the exempt seller disclosure about that. If the property is located in one of those developments, then seller has by default 3 days, if they haven't already, to order from and pay for the legally required HOA docs. And there's references here to a couple of forms, the HOA information request form and the HOA RS, which is an itemized list of the required HOA documents. The seller can use those forms to make these requests, but there's all kinds of ways to do it. Sometimes there's a way to do it through escrow. Sometimes there's a way to do it directly through the website of the HOA or their management company. So the form of making the request doesn't really matter. What matters is that the seller promptly requests these documents, pays for their preparation, and that all of the legally required documents are included. And so those are all listed out here which basically it cites the HOA RS, which is list the required statutory documents, things like bylaws and CC&Rs, sort of the big ones everyone's familiar with. But then there's other disclosure documents that need to be provided too, like if there's any pending litigation claims, parking and storage information, meeting minutes, HOA governance information, pet restrictions, smoking restrictions. So all of this needs to be provided to the buyer. And we've talked a lot about their obligation to review those. They have their 17 days or 5 days after the date of receiving those HOA documents to review and remove that particular contingency. All right, NHD. There's really two elements to the natural hazard disclosure obligation. So, talking about the NHD reports, seller always is required to disclose if the property is located in potential hazard zones, your 2 flood zones, fire zones, and earthquake zones. So that is typically done by ordering the NHD reports. And then most sellers, unless they're qualified for those TDS exemptions, most sellers are also required to sign and deliver the NHD statement that goes along with the NHD report. And then finally, there's also a mention in here, and this is a new addition because this used to get missed a little bit. Certain sellers are required by law to deliver the earthquake guide, the residential guide to earthquake safety, and fully complete and deliver the statement that goes along the back of it. So all buyers, you can always provide the earthquake booklet. It has useful information. But if the property was built before 1960, then the seller actually has to answer the questions at the back of the earthquake booklet as well. Good news, fun fact about the questions at the back of the earthquake booklet, that's the one disclosure form that actually has a checkbox that says, I don't know. So just keeping in mind that, they can fill that out to the best of their knowledge, pre-1960, required by law. And then finally, this, again, has always been the law and it's always been in the form, but it was moved into the disclosure section to really bring it to sellers' attentions. All sellers have the obligation to disclose all known material facts, all knowledge they have about the property, no exemptions. So even if your seller qualifies for TDS exemptions or other exemptions, they've got to disclose what they know about the property, on the exempt seller disclosure form or in any other format. That could include insurance claims within the past 5 years, if they have knowledge of that, and they can always put the buyer in, give them permission to do that due diligence themselves, but important material disclosures. On to paragraph 12, which talks about buyer's inspection and investigation rights. A lot of this is pretty similar to the old version of the form, but there are a couple of things to highlight here. Buyer, of course, has the right to do investigations about matters affecting the property. Whether or not they have the right to cancel based on the result of those investigations is going to depend on their contingencies. Buyer's investigation rights is really divided into 3 main categories, which is buyer's inspections for the physical condition of the property, home inspection, lead-based paint, wood-destroying pest inspection, any other sort of physical inspection they may want to get. Then there's all other buyer investigations like insurability or neighborhood issues, things like that. That's part of this investigation rights as well. And then, of course, reviewing any reports or disclosures or information provided by the seller. So buyer's investigation and inspection rights are really pretty broad, but there are some limitations to buyer's inspections and investigation rights. And really, those are outlined here, and they're important for the buyer to be aware of. The first is that without seller's prior written consent, the buyer can't have invasive or destructive buyer investigations done. So they can't be knocking down walls. They can't be having inspections done that are causing damage to the property. Now, there may be reasons why they want or think they need to do that. They just need to get seller's written permission first, and seller does not have to agree to allow the buyer to damage the property. To be done with seller's consent.
And then secondly, buyer cannot make or cause to be made any inspections by any government, building or zoning inspector or government employee unless required by law. So obviously, if there's a required government inspection, the buyer can set that up, but the buyer can't call out a city inspector just because they want to, if the law doesn't require it, to cause problems for the seller. That's not allowed without seller's permission. The seller, of course, has certain obligations to make the property available for these buyer investigations. And there are requirements of that, and there's limitations of that as well. So here's a new section that was just added that I think is going to clarify a lot of disputes. Seller's got to make the property available, but seller is not obligated to move any existing personal property. So get that question sometimes. The buyer wants the seller to move furniture or things around to make their inspections easier. They can ask, but the seller is not obligated to move furniture out or items around to facilitate buyer's inspections. The buyer's got to work with the property as it is. However, the seller is required to keep the utilities on. Water, gas, electricity, and pilot lights have to be on for buyer's investigations and throughout the date of possession. So that is a requirement. They have to keep those utilities turned on during escrow and specifically for buyer's inspections. Buyer, of course, is doing this to satisfy themselves with the condition of the property. One requirement to be aware of is that by the time specified in 3L3, your 17 days, or 3 days after receipt of any investigation report, whichever is later, buyer's obligated to give seller at no cost complete copies of those investigation reports. And that's true whether or not they continue with the transaction, whether or not they are requesting repairs, proceeding. If the buyer does inspections on the seller's property, they need to provide those inspection reports to the seller by the end of their contingency period or within 3 days after receipt if they get the reports later on. Big caveat here. This was always a question that arose, and we finally have an answer for it in this new version of the contract, which is fantastic, which is that this delivery of investigation reports shall not include any appraisal unless the appraisal is received with an FHA or VA loan. So buyer has to deliver pest reports, home inspection reports, but they generally do not need to give a copy of the appraisal report unless it's an FHA VA appraisal, because those stick to the property. So then it becomes relevant. Or, as previously discussed, if the buyer is going to cancel on the basis of that appraisal and utilize the appraisal contingency, then they would need to provide it in that circumstance. Final note about inspections. This is a holdover from the old contract, but it's something for buyers to be aware of. Buyer has to conduct themselves in a certain manner when they access the property for inspections. They need to keep the property free and clear of liens. If there is damage resulting from a buyer investigation, buyer is responsible for repairing that. They have to indemnify and hold the seller harmless if there's any liability as a result of their inspection. Basically, buyer is responsible for the consequences of their inspections and should proceed accordingly in choosing good, qualified inspectors and handling their inspections responsibly. Okay, title and vesting. A few updated things to highlight here, but largely this paragraph is just, establishing that the buyer is entitled to receive title insurance policy and ahead of time, a preliminary report to review what's going to be covered or not by their title insurance policy. That may be responsible for the seller to provide it, or if the buyer is the one paying for their own title report, they agree to act diligently and in good faith to get the preliminary report on time. Title remains, as it has been in previous versions of the contract, taken in its present condition, subject to all encumbrance or easements except monetary liens of record, unless buyer is assuming those obligations, or any other matters the sellers agreed to remove in writing. If there's a lien or matter not being transferred, seller has to take the necessary actions and deliver title free and clear of such lien or matter. And they have 7 days after request to give escrow holder necessary information to clear title. So Basically, this is normally going to refer to monetary liens of record, any existing loans, liens on the property. Seller has to clear those, and they have to provide the necessary information to title to get those liens cleared on time. Seller also has to disclose any matters they know that affect title, even if they're not on the title report. One important new thing to note here in paragraph 13E, which is a reference to this recent law, which refers to what are called geographic targeting orders. Basically, for certain transactions, if the buyer is an entity and they're purchasing a property for cash of at least $300,000, then there is a legal requirement that escrow obtains certain information from the buyer about what constitutes their entity, basically. It's essentially an anti-money laundering law. So if there is a legal entity purchasing expensive properties with cash, the federal government wants some information about who's involved in that entity so that they can better track down people who are using real estate to launder money. You know, probably never something you're going to encounter in your transaction, fingers crossed, but for certain transactions, if you have a buyer who's purchasing the property as an entity, escrow will require certain information from them, and per the contract, buyer is agreeing to cooperate with whatever request the title company has. Paragraphs F and G, nothing to rock the boat here, basically just confirming that buyer's going to get the necessary documents to put title in their name, and they will receive a title insurance policy. The default is they get the homeowner's policy. If that's not available due to any issues with the property, they get the CLTA instead, unless they negotiate with escrow for something different. If the buyer, obviously if they're not satisfied with the prelim, they have that cancellation right. But if they remove the contingency, then buyer is agreeing to close with whatever is offered to them.
Okay. Paragraph 14, contingencies, contingency removal. Love that paragraph 14 is the same number as it was in the old contract, a little bit of consistency and continuity for us here. And a lot of it is very, very similar, but there are a couple of clarification points that we want to make sure we cover. 14A still lists out that seller has to provide their documents within those first 7 days or whatever's agreed to. We know that. 14B talks about buyer has 17 days or whatever other time is agreed to or applies to do their investigations and review all their documents and sign and return disclosures. Buyer, during that time window, may make a request to seller to have the seller perform any repairs or provide any credits or things like that. Always a reminder that seller has no obligation to agree to or respond to buyer's requests. And if seller does not agree or does not respond, then buyer is not entitled to those repairs or requests. And if they still have their contingencies, they may be canceling based on their contingencies if they couldn't come to an agreement on repairs. Buyer, is responsible, been through a lot of this, responsible for removing their contingencies or canceling within the time frame specified. But if any report or disclosure for which seller is responsible, other than in paragraphs 11A or B, is not delivered within the 3N1 time frame, the 17 days, then they have those extra 5 days to review and the documents and remove the contingencies. And you'll notice that paragraphs 11A and B are carved out here. Those are those statutory disclosures. So basically, those have their own cancellation rights, right? We sort of went through 11A and B. Those are the TDS and the Nhd and the SPQ and the lead-based paint. And if those are provided late, then you have that rescission window right. It's for these other types of disclosures where buyer has this 5-day contingency extension if these documents are delivered late. And as a reminder, the delivery of the report does not revive the contingency. If the contingency has been removed, the buyer would need to rely on if the new information falls within those statutory disclosure requirements. And then finally, continuation of contingency. This is how, it's been in the contract for a while.
reminds everybody that our contract requires what's called active contingency removal. So at the end of your 17 days or whatever your time period is that you've agreed to, contingencies don't evaporate automatically. Buyer retains the right to cancel based on their contingencies until they've been removed in writing. And if that is dragging out, then seller has the right to issue a notice to perform and go through the seller cancellation process as described right here below. So 14C lists out exactly in what circumstances a seller may cancel the contract if they choose to do so. The first one is the one I've mentioned already. The buyer doesn't remove contingencies on time. Then seller can follow the notice to perform procedure and then cancel the agreement. But if they do that, then seller has to authorize the return of buyer's deposit unless there's any fees that the buyer has contractually obligated themselves to pay. So if you reach that deadline, or as you'll see below, 2 days before the deadline, and the buyer has not removed contingencies, seller can issue a notice to perform. Buyer still doesn't perform, seller can cancel, get out of the contract, but the deposit goes back to the buyer. There's a handful of other reasons why the seller can cancel. I shouldn't say handful. There's a laundry list of other reasons why the seller can cancel other than contingencies. Basically, anytime the buyer is not performing. So this paragraph 14C2, I'm not going to read them all to you. You can read them, but it lists out basically every contractual obligation the buyer has to do things at a certain time. Put the deposit in, provide proof of funds, accept solar leases or liens, comply with the geographic targeting order. Basically anything in this contract that says the buyer is going to do something. If the buyer doesn't do it on time, then the seller can cancel after going through the notice to perform process. But similarly, if that happens, seller will authorize the return of the deposit unless there are fees that the buyer has agreed to pay via escrow, and they're already paid. So one thing I do want to point out here, this is broader than it was in the old version of the contract. There used to just be 5 or so contractual actions the buyer had to take. Now there's 11, including a catch-all for performing any additional buyer contractual obligations included in the agreement. So if the buyer misses any deadline that's in the contract, the seller can give a notice to perform and then cancel based on the buyer missing that deadline. So that includes anything we've mentioned the buyer's obligated to do. And then finally, the third way a seller can cancel, of course, is if the seller themselves has a contingency. Really the only time you're going to encounter that is if there is a seller contingency for purchase of replacement property. If the seller, typically via counteroffer, has said this is contingent on me finding a replacement property attached to the SPRP form, and they aren't able to satisfy that, then of course the seller can cancel the agreement by good faith exercise of any contingency they have, as long as they haven't removed it also. And then buyer's right to cancel is pretty straightforward. Obviously, skipping right down to 14D3, buyer can cancel the agreement by good faith exercise of any contingency as long as it's not been removed in writing. So very straightforward. It's a question I've been getting for years, which was where in the contract does it say that buyer can cancel if they haven't removed their contingencies? And now there is plain language that says it. So hopefully that clarifies for any confused buyers or sellers. And then the other way out for a buyer is if, even if they have removed their contingencies, if the seller is not performing, if the seller doesn't remove any contingencies they may have on time, the buyer could give a notice to seller to perform and then cancel. Or if the seller is not honoring their contract obligations, most notably, that's going to mean providing documents, providing the disclosures or reports or things like that, seller can give a notice to perform and cancel. But if there's any other seller time frame obligation and the seller hasn't performed, buyer can give a notice to seller to perform, and then they can cancel as well. So how does the notice to perform process work? So this is pretty similar as it has been in previous versions of the contract, but I do want to note a couple of clarification points in here. Notice to perform has to be in writing, has to be signed by either the buyer or seller, whoever's giving notice, and it has to give the other party at least 2 days after delivery or the time specified for the deadline, whichever is later, to take the action. Now, it used to say 2 or blank days, and so there used to be a lot of confusion about if you could change that time frame, or if someone sort of snuck a change in and someone didn't notice it, or if you could change it later. Well, any sort of confusion is gone, not modifiable. Notice to perform has to give 2 days after delivery to perform. And the earliest you can give a notice to perform is 2 days prior to what's called the scheduled performance day, whether or not that falls on a Saturday, Sunday, or legal holiday. So we're going to get to counting days in a second, but you may be familiar with this concept, which is, we count all calendar days in our contract, and sometimes you count, let's say, to day 17, and that day 17 falls on a Saturday. So that's your scheduled day for performance. You can give a notice to perform 2 days earlier than that. However, the actual performance day is going to roll over to the next business day when you have a deadline that falls on a Saturday, Sunday, or holiday. That's all explained straightforwardly a little bit further down, and we'll get there in just a second. All right. Oh, another important clarification is I really like this change because this had been sort of a bit of an open question or point of confusion for people. What happens if someone messes up this process? What if someone gives you a notice to perform that, they give it to you a week ahead of time instead of 2 days ahead of time, or in some other way that violates the provisions of this contract? Well, now it says, if a notice to perform is incorrectly delivered or specifies a time less than the agreed time, then the notice will be deemed invalid and void, and whoever sent that notice has to deliver a new one. So you can't just say, well, just keep my incorrect notice and apply it the right way. If a notice is delivered incorrectly or invalidly, it's void, and that buyer or seller has to re-deliver the notice in the appropriate manner for it to be valid and binding. Paragraph F here basically just reminds both parties about the effective removal of contingencies. If you remove your contingencies, you're committing to closing, more or less. You've completed your investigations, you've reviewed everything that's been provided to you, you're proceeding with the transaction, you're assuming any risk of any information you don't know, or an ultimate inability to get financing. And if the seller removes their contingencies, if they have any, they are committing to close regardless of any outside circumstances. So then the question becomes often, well, what happens if you get to the end of the transaction and now one side or the other isn't closing? A common mistake is someone just cancels. They think, well, we were supposed to close 2 days ago, so sometimes I'll hear we're out of contract or our contract's expired. But that's not exactly how the contract works. Those are figures of speech. But the contract does not go away on its own. You are not out of contract and the contract hasn't expired. You've just missed the scheduled close of escrow date. So if you've reached the close of escrow and one side isn't closing and the other side does not want to wait around, then that's when the demand to close escrow process comes in. Very similar to the notice to perform, except for it gives 3 days instead of 2. And it basically is saying, you have 3 days to close, or I can cancel this agreement. And this is true whether or not contingencies have been removed. Once you are at the close of escrow date, you can give no earlier than 3 days prior to the scheduled close of escrow date. Give the demand to close. If the other side isn't closed, then the delivering party can cancel the contract. And if the buyer's already removed contingencies, and then they don't close after getting a DCE, that is a case in which their deposit would be at risk. The seller could say, I'm canceling and I'm pursuing your deposit because you did not close escrow after after you removed contingencies and I gave you the appropriate notice. All right, final note on contingencies and cancellations and deposits here. The parties are agreeing that if either side gives notice of cancellation, exercising their rights pursuant to this contract, the parties agree to sign and deliver mutual instructions to cancel the sale and release the deposits to escrow
less any fees and costs or any agreed upon escrow cancellation fees, depending on what the escrow holder provided. There is a big bold warning here that a release of funds will require mutual signed release instructions from the parties or some sort of binding legal order. Often it can be frustrating when one side or the other cancels, the other side wants to fight. Even if it seems crystal clear that the procedures in the contract were followed and one side is exercising a valid cancellation right, escrow is not going to automatically release the deposit to either side or make the determination of what constitutes a valid cancellation. They will require mutual instructions or the parties to go through the legal process. One thing you can note to a non-cooperative party is that if someone is refusing to sign cancellation instructions just because they're mad and not because there's a good faith dispute, if the other party basically knows that the other side has the right to cancel or is unhappy about it, they still have to sign the cancellation anyway, and they could be subject to a civil penalty of up to $1,000 for refusing to sign the cancellation instructions if there's not an actual argument that they should get the money. But there's a note here, agents and escrow holder can't really tell the buyers or sellers what's a good faith dispute. If there is any sort of dispute about the deposits, buyer and seller are always advised to talk to an attorney sooner rather than later to figure out how you can move forward. We talked about the notice time periods up here being 2 or 3 days and took away the or blank. If the parties want to alter those notice time frames, it could still be done. These are still prescribed by contract and not by the law. So if a seller in a counteroffer wanted to reference these paragraph numbers and say these notice time frames will be 1 day or in an addendum or an amendment, something like that, they're modifiable. It's just not built into the contract. The contract leaves it as a default set number of days, but the parties can negotiate and can put into a counteroffer or other terms or an addendum or amendment if they want to modify these time periods. Paragraph 15 talks about seller's obligation to perform repairs. If the seller does agree to perform repairs, they don't have to, but if they do, they need to complete those prior to the final walkthrough, unless a different time frame is agreed upon. They have to complete them in compliance with any laws and be done in a good, skillful manner with materials of the closest quality and appearance possible to what exists. Furthermore, if the seller hires an outside vendor to do the work, seller should obtain invoices and paid receipts. Or if they do it themselves, they should write out a written statement of what they did and provide copies of the invoices or the statement to buyer for the final walkthrough. So again, that way the buyer doesn't have to take the word for it. Oh yeah, we fixed that leaky faucet. The seller should provide the invoice from the plumber or whoever they used to show that the agreed upon work was completed. And that should be done at or prior to the final verification of condition. As we mentioned up in 3J, there's a default 5-day time period window, 5 days prior to closing escrow. You could modify that, but that's the standard, where buyer has the right to do a final walkthrough, not as a new contingency. So if the buyer's removed all contingencies, they can't walk through and say, oh, actually, I'm not happy after all, I'm canceling. The entire point of the final verification of condition is solely to confirm that the property's been maintained, in the appropriate condition as required by the contract and is laid out in paragraph 7B, or if repairs have been completed or were required, that those have been completed and that sellers complied with all obligations. If there are any problems, the VP form is the place to note those. Paragraph 17 deals with prorations. This is all items that are typically covered by escrow, although you always want to encourage your clients to double check to make sure that escrow handled this properly and that things are prorated in the way they expected, breaking down what should be paid current, what should be prorated, and then what is buyer responsible for in terms of things that happen, whether it's pre-escrow, mid-escrow, or post-closing. 2 things to note. Any tax bills or utility bills that are issued after closing are going to be handled directly by buyer and seller once that escrow is closed. Buyer and seller have to work that out directly. And prorations are always made on a 30-day month, even if it's a February or a 31-day month, shorter or longer. 30 is the default. Paragraph 18 references brokers and agents. We've talked a few times about how brokers and agents are not parties to the contract, but seller or buyer, as applicable, are agreeing to pay compensation to their brokers as specified in separate agreements, and that compensation is payable at closing, or if escrow does not close, as otherwise specified. And then 18B really talks about the scope of duty, and this is a good paragraph to encourage your clients to read, basically reminding them of things you hopefully have already discussed, which is you're not making determinations of price, you can't independently guarantee the condition of the property or the quality of inspections. And then the rest of this paragraph basically lays out the limitations of an agent visual inspection, and also that you are not going to be giving legal advice, tax advice, or insurance or title advice. Really encouraging the buyer or seller to consult the appropriate professional and not lean on you for specialized advice, especially legal, tax, and insurance advice. Paragraph 19, this is the joint escrow instructions to the escrow holder. Basically, this flags for the escrow holder. Here are the paragraphs that include instructions to escrow, things that are going to deal with time frames and cost allocations, most importantly. But also, this is where it talks about buyer and seller agreeing to sign and return escrow holder's general provisions, default time period of 5 days, as mentioned up in paragraph 3. Also, the parties agree that if there's going to be any modifications, counteroffers, or addenda, those are going to be delivered to escrow holders 3 days after acceptance. So you've got to keep escrow in the loop for any relevant changes to the contract. And then down here in paragraph C also is where it talks about escrow holder agreeing to act as a qualified substitute if they are able to do so. And generally, they acknowledge that they're only going to pay bills if there's invoices, and that they will follow up on things like verifying that buyer has successfully put the deposit in escrow, and that escrow will notify the parties if buyer's deposit funds aren't valid or if there's any other issues with funds coming into escrow. A couple of advisory notes here. As always, agents can't guarantee the performance of vendors like inspectors, so buyer and seller should choose on their own which inspectors they would like to have. Paragraph 21, there is a new change in here. Basically, this section authorizes agents to report information to the MLS. That's good, and that's always been there. But there's a new section here where the buyer acknowledges that there's going to be images and pictures of the property that are in the MLS, and that those will stay up even after escrow closes, and that once those images are placed into the MLS, they are syndicated out to the internet, and it basically becomes beyond anybody's control to get those items down. Sometimes you would have situations where post-closing buyers would say, get those pictures of my property off the internet. Well, now in the contract, the buyer's acknowledging that those pictures will stay up, and that frankly, it's beyond most anybody's control once things are on the internet to remove them. Paragraph 22, attorney's fees paragraph, basically says if there is a legal dispute, whoever wins, the other side pays their attorney's fees, assuming everybody followed the appropriate dispute resolution procedures. We are now finally at the assignment paragraph. So previously, in the old version of the contract, it just said that buyer couldn't assign the contract without seller's consent, and seller's consent couldn't be unreasonably withheld. Well, as a lot of you acknowledged as we were talking about the timeframes, that circumstance could get really messy and headachy depending on last-minute requests and what does unreasonably withheld mean. So this new paragraph 23 really lays out the specific options for both buyer and seller in the event that the buyer needs or wants to assign all or part of their interest in the contract. So
If, for example, the buyer is an individual, they write up the offer as an individual, but they decide they actually want to purchase into their trust or purchase into a wholly owned LLC or other sort of legal entity that already exists, then buyer does not need seller's consent for that. Buyer can on their own say, hey, I know I wrote the offer as an individual, but I'm going to actually transfer this to my trust and take title of my trust. Or I know I wrote the offer as an individual, but I by myself have created a wholly owned investment company and I'm going to purchase the property in my investment company. And that they can do on their own. Otherwise, if there's any other sort of assignment arrangement at play, buyer can't make that assignment without getting seller's written consent to that specified assignee, and that consent still shall not be unreasonably withheld. Well, now we have some more explanation of what does unreasonably withheld mean, what does this procedure look like. So prior to any assignment, buyer has to disclose to seller the name of the assignee and the amount of monetary consideration, if there is any, between buyer and assignee. So if the buyer is doing something that some people call wholesaling, or sort of like flipping the contract, they have to tell the seller, yeah, I'm assigning the contract and that person's paying me $10,000 to take over my spot as buyer. Has to be disclosed. Buyer also is required to give the person they're assigning the contract to all previous documents, the contract and any disclosures. If the assignee is just the buyer in another format, as a trust or an entity, they don't have to go back and re-sign or initial all the documents again because it's still just them. But if it's a new person, if they are assigning to a family member, they're bringing on a co-buyer, they're assigning to a whole other person, if there's a new person coming into the transaction, that person will need to actually go back and re-sign or initial documents provided. And that's going to be laid out in the assignment of agreement addendum, the AOAA form that will be used if an assignment takes place. Another obligation of the buyer is when at the time of the assignment, the assignee has to provide a pre-qual letter or pre-approval letter, just like the original buyer did, showing that they are qualified to purchase this property or pre-approved. And if they don't, seller can say no assignment. They can terminate the assignment after giving notice to perform. Buyer has 17 days to deliver any request to assign this agreement for seller's consent. If buyer fails to provide the required information within that 17-day time period, seller's withholding of the consent shall be deemed reasonable. So beyond the 17 days, the seller can say, sorry, it's too late. You had 17 days to request this. If the buyer is willing, if the seller is willing, they can choose to consent, but they now have the option to not consent. After the 17 days, that will be deemed a reasonable exercise of their right to not consent. And then just a statement that a partial or total assignment does not relieve the buyer of their obligation. So the buyer, unless something else is agreed to, but if the buyer brings on somebody else or even assigns somebody else altogether, original buyer remains liable on the contract, just in case.
All right, paragraph 24, one-line statement, but an important one. Property sold in compliance with federal, state, and local anti-discrimination laws. Hopefully everybody looked at the Fair Housing and Discrimination Advisory that came attached to the contract at the very front. Paragraph 25. This is a really important paragraph. It's an updated version of a paragraph that's always been in the contract, but that I think has been largely skipped over because it's a lot of text and it's towards the back. But you'll see throughout the contract the use of certain terms that are capitalized, sort of in strange places. And when you see that, if you see a word in the middle of a sentence that's capitalized, that is what is called a defined term. And you can come back here to paragraph 25 and say, oh, I see, the word acceptance or the word day or deliver is capitalized. I better go see what that means. So I had a question a long time ago about what does acceptance mean? And acceptance means the time the offer or final counteroffer is fully executed in writing by the recipient party and is delivered to the offering party or that party's authorized agent. So what does that mean? That means if there's no counters, buyer writes up an offer, sends it to the seller. When the seller signs it and delivers it back to the buyer or their agent, and we'll talk about what delivery means, that's when you have acceptance. So it's when it's sent back. Can you use the ASA for new assignees so they don't have to go back and sign already executed documents in case some are missed? Not how it is scheduled to work, not how it is set up to work, unfortunately. I know it's a lot of paperwork for new buyers to go back and sign everything that came before, but it really is important from a risk management perspective so that nothing does get missed. So that the buyer, that's the whole point, is so that the new buyer goes back and signs their initials on everything that came before, so that they can't say that they didn't see something. It's really important to get their eyeballs on it. And the buyer and the buyer's agent should make sure that that happens. Okay, a couple of more important terms to highlight in here. Definition of as-is condition. There's often a misunderstanding that if the property is sold as is, that means that the seller doesn't have to do anything and the buyer doesn't have any inspection or contingency rights. But no, as is means that the condition the property was in at the time of acceptance, that the seller has no obligation to make any repairs unless they choose to do so. But seller still has to disclose material facts and defects, and buyer still has the right to inspect the property and request repairs or cancel if they have contingency rights. So as is simply means seller doesn't have to make any repairs if they don't want to, but buyer can still have contingencies, buyer can still request repairs, and the seller can just say no. There is a definition of what somebody's authorized agent means, which is the name of the agent specified down in the real estate broker section on the final page of this contract. That's one of the last things we'll take a look at here. But there is a spot, the broker box on page 16. That's where you will put in the individual agent or agents. There's room for more than one, to put in as the officially authorized agent to receive documents on behalf of the buyer. This is some of the most important, exciting changes that are in the contract. One is this explanation of counting days. So the way we count days in the contract hasn't changed, but you used to have to sort of piece it together by look at the definition of days, look at the definition of days after, and put that all together to figure out how days are counted. Well, now there is just this instructional paragraph that tells you exactly how days are counted, which basically is, to summarize, the date that an event occurs, like a notice is given, that's day 0. You don't count that day, whether the notice is sent at 9 a.m. or 9 p.m. That is day 0. And then you count full calendar days after that. So day 1 is the next day, day 2 is the day following, and the parties have the full calendar day until 11:59 p.m. to perform. And as we hinted at earlier, if that deadline falls on a Saturday, Sunday, or legal holiday, then the allowable performance day will roll over to the next day that is not a Saturday, Sunday, or legal holiday. And then further, close of escrow, if the close of escrow date happens to fall on a day where the recorder's office is closed and it's not possible to close, then closing will occur on the next day that the recorder's office is open. Typically that lines up with Saturday, Sunday, and holidays, but every once in a while, there might be a random closing of the recorder's office, and that will also push back the close of escrow deadline for the parties. Okay, so I know we have about 13 minutes left. The good news is we're almost done, but there's a really important piece of information that I want to share with you here, which is here in paragraph 25K, the definition of delivery. So previously, the definition of delivery meant only when whatever document was sent was personally received by the other side. And personally received could be really, really hard to confirm. How do you confirm someone has personally received something? You could ask for confirmation. You could ask for them to respond to you. But if they didn't, then you were kind of, you would struggle to confirm their personal receipt. Now, however, delivery, so when a document is effective and considered delivered, could be when that document is confirmed in possession of the party or their agent, or when an electronic copy of the document or a link to it has been sent to any designated electronically delivery addresses specified down below. So what does that mean? I'm going to bounce down here to paragraph 16 very quickly. In this broker section,
it's the same as it's always been with broker and agent information, except now the parties, the agents, can designate emails or cell phone numbers for texting to be their designated delivery addresses. And if you do that, then documents will be considered delivered when something is sent to that email address or that other electronic method of delivery. So the hope here is this really helps facilitate better timeframes in your transactions. You don't send something and wait to hear if somebody actually got it or not. It's going to be a really sort of smoother process for people to provide email addresses, provide electronic delivery addresses. And that way for both sides, when someone hits send and says, okay, I've sent this notice, it is effective upon being sent to that email address or that other method of electronic delivery. And you're not running around chasing somebody down, trying to, confirm whether or not they received it. So hopefully that's going to really take away that headache element of trying to track down somebody. You get their email address on the form, you send something there, it's considered delivery or effectively delivered. If they want to change that during escrow, they want to change out an email address, that can be done in writing.
Paragraph 26 and 27, those are the same as they have been in previous contracts, basically saying, all of these terms and conditions are important to the contract, but highlighting that liquidated damages and arbitration, which are on the next page, are only incorporated in the agreement if all parties initial or if accepted through a counteroffer. If one but not all parties initial, liquidated damages and arbitration on the next page, you have to use a counteroffer until an agreement is reached. Otherwise, you don't have an agreement on the material term of the contract, and you can't proceed until that's been resolved. Also, there's a note, I've gotten this question before, can the contract be signed in counterparts? So if you have two parties, do they have to sign on the same physical copy, or can they sign identical documents on different signature pages? They can do that. That's called signing in counterpart, and that is allowed. Reminding the parties that the only way to modify the agreement is that it has to be in writing and signed. So we kind of get this question a lot. Can the parties modify the contract by sending a text saying, sounds good, or something like that? The only way the agreement is actually going to be modified is if it's done in writing and actually signed by the parties. All right, paragraph 28, legally authorized signer. This used to be called representative capacity, and it's the same concept, which is if you have a buyer or seller who isn't acting in an individual capacity, but they're acting as the legally authorized signer for a trust or a probate or an LLC or some other sort of entity, then they have to disclose that to the other side, and they have to provide what's called evidence of authority to both the other party and escrow, showing that they have the right to act in that capacity. So a trust certificate, orders from a probate court, an authorizing resolution from a corporation, all of those things can be used to show that they are acting in the capacity. What about the RCSD? You might be asking, do we still have to do a representative capacity signature disclosure? The great news is, no, you don't, not in most cases. The signature block is now set up where the legally authorized signer can be put directly into the signature page of the contract. And we'll get there in just 1 second. All right, paragraph 29, 30, and 31. The dispute resolution portions of the contract. This has been moved down towards the end. So this is the last portion of the contract before it's signed, which is good because this is where initials go as well. And also these boxes have been added to really draw the party's attention to these sections and let them know, hey, this is important, not because initials are mandatory here, but because there needs to be an agreement. So the parties do not have to initial these sections, but it's all or nothing. So either both buyer and seller initial or both buyer and seller don't. So the provisions come in the contract or they don't. You can't have just one or the other. So liquidated damages, I mentioned this up at the top. This is where the parties can agree in advance that if the buyer breaches the contract, typically means failing to close with no contingencies, seller is entitled to retain as their damages the deposit actually paid. If it's a residential property that the buyer is going to occupy that is capped at 3%, the seller can go after up to 3%, but they are entitled to the deposit with a 3% cap. If the deposit is higher than that, then the seller needs to return any excess, and the 3% is the most they can keep. And we've talked a few times about if there's an additional deposit, you use that DID form to incorporate it into this paragraph. Then we have mediation and arbitration. So these are the dispute resolution portions. Mediation applies to all contracts. There's nothing to initial for mediation. Even if the parties choose not to initial arbitration, then they are agreeing to mediate by default. And basically what this paragraph says, mediation is a non-binding form of dispute resolution. If there is a dispute, the parties will attempt to mediate it first. Agents are not required to take part in mediation, but they can choose to do so if they want. And mediation is important because attempting mediation is a requirement to preserve your right to retain attorney's fees if the dispute goes forward from there. And then arbitration is a binding form of dispute resolution. This is where the parties have to opt into to basically waive their right to go through the public court system in front of a judge and jury, and if they so choose, and instead opt for private arbitration. Again, it's optional. If your clients have questions about the pros and cons of arbitration, please remind them that that is legal advice and encourage them to talk to an attorney about whether or not it's a good idea for them to agree to arbitration. There's pros and cons on both sides in terms of due process, potential speed, appealability, but you don't want to be giving your clients legal advice about whether or not they should waive their legal right to go to court and choose private arbitration instead. They should read this section and seek legal advice as necessary. One new element of this provision is that the default says that the parties will choose an arbitrator. They'll mutually agree to one, but they can agree up front. They can choose a service provider. There's multiple companies who offer arbitration services around the state. So if they know in advance, hey, if there's an arbitration, we want to use such and such arbitrator service, that can be agreed to up front, but it's optional. They can always just leave it as the default and say, we'll come to a mutual agreement later. And then finally, important to note the exclusions here. Certain matters don't have to go to mediation and arbitration. Most commonly, matters that qualify for small claims court jurisdiction. So if it's a relatively small dollar amount, typically up to $10,000, then the parties don't have to spend the time and money to go through these legal procedures. They can go straight to small claims instead. We are at the final pages of the contract here with just a couple minutes to go. So we already talked about the time frames for expiration of offer. This just references back to the time up in paragraph 3C. Could be 3 days, could be modified. Then now is where we have the checkbox that replaces the RCSD form. So if you have an entity buyer or seller as applicable, so either 32B or 33B, then you check the box, which automatically states that one of the buyers or sellers is a trust, corporation, LLC, probate, etc. Then it's being signed by a legally authorized signer in a representative capacity. You give the name of the legally authorized signer. So, your buyer might have been listed as Investment Company LLC, and then your legally authorized signer might just be Jane Doe, who's acting as a legally authorized signer. Or if you have sometimes a very long entity name, sometimes the name of the trust or a probate case is so long that it won't have fit up top in where you identified the buyer in paragraph 1. So if that's the case, if you had to use a simplified name, then down here in paragraph 32B4 or 33B4 for buyer or seller, Then here's where you put the complete legal name of the trust or the probate case if you couldn't fit it elsewhere in the contract. Then we have the signatures. So if the buyer's not an entity, they'll just sign and date, and that's it, and print their name. If the document's being signed by a legally authorized signer, then they will print their own name below and state their title if applicable. So trustee, administrator, president, manager, whatever the case may be. There's room for 2 signatures here. If you have more than 2 buyers or sellers, this is where you check the box to use the additional signature addendum, the ASA form. That will attach, and it will just provide more blank signature lines so that your clients can sign attached to this on that additional page. And then down here is where the seller can sign to accept. If the seller is just accepting the offer straight away, they can just come straight down to paragraph 33D and accept the offer. Congratulations. But if the seller's acceptance is conditional, if they're going to do a counteroffer, make sure the box is checked in 33A for counteroffer. Or if they want to go straight to putting the offer in backup, maybe the offer is great, but they have a current escrow that they're waiting out, then check the box in 33A for backup offer, and you can attach that addendum to basically state, hey, we like your offer, but it's subject to the cancellation of our current contract that we are under. And then finally, at the very end, there is a reminder for both parties that this RPA is 16 pages long, and they acknowledge that they have received and read and understood every page and any attachment. And then that's it. As far as the terms of the contract itself, this is where you obviously sign if you are accepting or countering. If the seller just says no, if the seller just says, nah, I'm not going to accept this offer and I'm not going to counter it, then there is a handy space here for them to initial that, yes, they received the offer, but no counter is being made. It's mostly a courtesy for the buyers to let them know, yes, we did see your offer, but no, we're not countering or accepting it. Not required by law that the seller do that, but it's a good practice just for courtesy and to, keep track of what offers were reviewed. And then our final page, we already talked about this real estate broker section a little bit. This is where basically it confirms you're not parties to the contract. The agency relationships were established up top in paragraph 2, but, seller's broker and buyer's broker may have their own arrangement for compensation, typically the amount specified in the MLS, although that can be modified on a different form. And also reminding buyer's agents that they have the right to request written confirmation that their offer was presented and that there's a code of ethics standard of practice that requires the seller's agent upon request to confirm that that took place. And then I already mentioned this, but this is where all the buyers and sellers brokerage information goes, including that new handy trick for electronic delivery. And then finally, escrow holder acknowledges that, yes, they have a copy of the contract. It's a contract whether or not they fill out this section, but escrow should do that. There's also a place to indicate what type of escrow you're dealing with. Independent, which is the Department of Financial Protection and Innovation, insurance, or DRE. And then here's where a listing agent can confirm they presented the offer. In this broker section here, if the brokers put in or the agents put in email addresses, they are authorizing the other side to deliver documents to them electronically and have those documents considered delivered upon proof of the fact that those documents were delivered. So if someone hits send on an email to your valid email address, that's going to constitute delivery. Oh, one more note you might have noticed, there's not a confirmation of acceptance section anymore. That has been taken out due to the fact that there was a lot of confusion mostly about whether or not it was legally required, and it wasn't. So there is no more confirmation of acceptance. It's accepted, and then you send it back and deliver it, and that's what creates your contract. And then we still have our presentation of offer confirmation. So that's it, guys. That's page 16 of the contract.